May not have a small prayer. Uh, at the bottom of the list, 3031, there are two cases involving the sub-inspectors of police. That matter, my lord, I had argued on the last occasion. So I don't have much to say in that case. I'll make my submission, but I was told that the government advocate who's appearing in that case, Mr. Tapin, he is unwell. So he is not in a position to give his reply. This is what I was told. So, my lord, if that be the case, because tomorrow, my lord, I have got a matter before my lord, the Chief Justice in court number 1. So after completing my Dibang case, if after the motion items, if 3031 can be called up, I'll finish my part. I won't take much. And whatever subject to whatever Mr. Tapin submits after 2 days or after a day, whatever, whenever, I will supplement it with my written argument. I can always give written argument to your lordship. So, my lord, after the motion matter, my lord, that may be called up because that is part heard. I'll finish this.
My please, lordship, my lord, I may be allowed to withdraw, my lord, agenda 21 to 24, my lord. With the liberty, my lord, to approach.
Mr. P. Toffel, Lord Counsel for the petitioner, submits that he has instruction to withdraw these petitions. Here is accordingly allowed. This red petition stands disposal on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Apply, oblige.
And then 20 also, it's finished. 20 was IA. If it is withdraw, 21 withdraw that also.
20 will automatically go, my lord. It's IA, my lord.
Yes.
When there is no case, my lord.
20.
Yes.
Obvious.
In view of order passed in WPC number so and so, 357 of 2024 IA, within bracket C, 230 of 2024 also stands disposal.
Oblige.
May I please, my lord. My lord, I beg to mention item number 6, my lord. My lord, here client want to give some instruction, but he is out of station, my lord. And I will take consent from the respondent.
You
Matter
are
may
the
be
respondent,
yes, now I am petitioner.
petitioner.
Yes, my lord.
Your good name?
N. Sora, Nyalu Sora.
Mr. N. Sora, learned counsel for the petitioner, with consent from the other side, press for any objection?
No, madam.
No. Press for listing the matter when?
After 3 weeks, my lord.
After 3 weeks. We are allowed.
Deeply obliged.
I would like to mention item number 1819, my lord. I'm appearing for the respondent, my lord. I'm taken consent with the petitioner.
Item number 18 and 19.
Yes, my lord. I'm appearing for the respondent. Matter may be fixed for 16, my lord.
Or
Matter may be fixed on 16, my lord.
16.
Yes, my lord. Our pleadings have been completed, my lord. Maybe list on admission hearing column.
Okay. Or Mr. Your good name?
Pramod Kumar Gaur.
Learned counsel for the applicant. In both the cases, you are for the
Respondent.
In-
Petitioner is there.
in IA 71, you are for the petitioner.
Respondent, my lord. Respondent number 2.
Item number 18.
Item number 19, I'm appearing for 1 and 2. And item number 18 for 2 only.
Learned counsel for the respondent, with consent from the other side, press for listing the matter on
16, my lord.
16th. It is also submitted that service has already been completed. And
My
the
lord, pleadings
matter-
have been completed, my lord.
pleadings
pleadings,
completed,
yes.
and the matter may be listed in the column of admission hearing. Here is accordingly allowed. Rest is list the matter on 16. Yes.
Lordship, I beg to mention the item number 26 and 27. Petitioners.
Item number
26 and 27. Yes.
27.
Yes. Petitioners does not intend to proceed the case further, so I may be allowed to withdraw the case here.
Okay. Mr. Your good name?
T. Bagang.
Learned counsel for the petitioner submits that he has the instruction to withdraw these petitions. Where is accordingly allowed. Whether liberty will be required?
Yes, Lords.
However,
Liberty.
liberty will remain with the petitioner to approach this
My
court
lord,
again as and when required.
No liberty. No liberty this case.
Why?
They approach many occasion and they withdraw. Different petition.
No, no, Lordship.
No.
Earlier
this
there
case,
was 3 petitioners. Simple.
we are granting liberty. Okay. Okay.
Stay order will
Stay
be
order.
vacated. There was a stay.
Definitely, stay order passed earlier. Stands vacated.
Deeply obliged.
Last time I advanced my argument, my lord.
Yes, yes.
I completed. Only I will not let my learned friend complete his argument. Only 3 minutes I'll just take to just what my learned friend.
My lord, I'm grateful to my esteemed colleagues. Earlier, I was arguing against myself. I was assuming and presuming that the respondents may argue this or they may argue that. And on the basis of that, my lord, I was advancing my arguments. Now at least I'm clear. Now, my lord, having gone through the whole gamut of the case, there is only a short question which is involved in this case for your lordship's consideration. Namely, as to whether the private land of an individual, which is covered by cultivation or by horticulture, is entitled to the benefits under Chapter 9 of the RNR Policy 2008. That is the short question involved. Because so far as application of 2013 Act is concerned, with regard to application of the principles of compensation assessment, there is no dispute about that. Even the NSPC is not disputing that. Yes, they are entitled to the benefits of the principles of compensation assessment under the 2013 Act. The only issue is as to whether the private land of an individual covered by cultivation or by horticulture is entitled to the benefits under Chapter 9 of the RNR Policy 2008. That is the only issue. Now, my lord, the arguments of the respondents, the arguments have two components. The first one is factual, other one is purely legal or quasi-legal. So far as the first component is concerned, my lord, with regard to the facts, I will deal with that component first. Now, my lord, the first argument was on factual aspect. The reference was made to, my lord, acquisition of land, acquisition of 150 hectares of land at Sisho Ataya, which my lord will find in WPC 230 at page 392, 394, 395, please. WPC 230. Page 391, my lord, it starts. Acquisition of 150 hectares of land at Sishu Akaya. That document was placed to advance an argument that in a similar case, NSPC has already made the payment.
Page number 3.
Page number 391, my lord.
Yes.
391. I also, in my, this is a big petition. Now, my lord, example was given of Sishu Ataya case, and it was argued that, look, in a similar case, the benefits were given under Chapter 9 of the RNR Policy 2008, apart from giving them the benefits under 2013 Act, NSPC conceded to that. So the case is absolutely similar. My lord, the answer is case is not similar. What happened in Sishu Akaya? My lord will find page 391. Name of individual, the column 1.
Yes.
There are 3 individuals. As to who are these 3 individuals, I will clarify. Category of land, uncultivated land. Now, my lord, yes, it is true the benefits are given. The clarity will come the clarity will come. My lord will find page 394. Page 394.
Yes.
Location, description, and total area of land. The land under acquisition is community land, uncultivated hill land, situated at village Shishu Ataya and Rowing Circle, Lower Dibang Valley district, measuring 150 hectare, 1,50,000 square meter. It is a community land, uncultivated hill land. Since it is, my lord, a community land and uncultivated hill land, that is why my lord will find at page 395. Page 395, the chart. To whom the payment has been made? Number one, representative of Pulu Ataya clan. 2, representative of Ilapra Sisho clan. 3, representative of Mi Sisho clan. There are 3 clans who had control over this very particular uncultivated hill land, which is the community land. The representatives of these 3 clans were given the compensation. Now, my lord, there is another aspect to this. Sishu Ataya. Sishu Ataya, my lord, this 150 hectare is a part of 4,577 hectare of the main project.
Yes.
This 150 hectare, my lord, is a part of 4,577 hectare of the main project, which was diverted, and for which there was in principle approval of the Government of India under Section 2 of the Forest Conservation Act 1980.
Yes.
So, my lord, this land was diverted. It is part of 4,577 hectare of the main project. For some reason, my lord, this land could not be acquired. This was the only portion left out. But there was already a, my lord, in principle approval of the Government of India under Section 2 of the Forest Conservation Act. For a moment, my lord, Section 2 also may kindly be seen of the Forest Conservation Act 1980. When a forest land is used for non-forest purpose, it is required to be diverted with the approval of the Government of India under Section 2 for non-forest purpose. (1980) Forest Conservation Act.
Come on, this is good.
That is, my lord, restriction on de-reservation of forest use. Oh, sorry. Yes, yes. Forest Conservation Act 1980 is there. Internal page, my lord, will find page 103. Our book is same, my lord. 103, my lord will get Forest Conservation Act. Whether my lord has got it. My lord, may I help you?
Considering it is a road,
My lord, it is here. I think it is only. We have a different, no, it will be one section. Now it is translated. They have the portion, it is translated. Milord, section 2, page 104. Mine is the anglicized version, they have got pure Sanskritic version. It is translated, one Adirakshik Niyam or something that,
Yes,
at page 104.
restriction on
Yes,
reserve
my lord.
reservation.
Notwithstanding, it begins with the non-obstant clause. Notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, any order directing that any reserve forest, such and such, within the meaning of the expression reserve forest in any law for the time being in force in that state or any portion thereof shall cease to be reserved. 2, that any forest land, not only reserve but any forest land or any portion thereof may be used for any non-forest purpose. 3, that any forest land or any forest thereof may be assigned by way of lease or otherwise such and such to any private person, etc., etc. So this is it, my lord. No forest land can be used for non-forest purpose without the prior approval of the central government. Now, so far as this 150 hectares is concerned, it is part of 4,577 hectares of the main project, for which there was already in principle approval of the government of India for its diversion. There was in principle approval and there was a proposal also by the government of Arunachal Pradesh. And my lord, it is nobody's case that so far as the present land is concerned, involved at Vishpak Nagar, there is in principle approval of the government of India for its diversion under section 2 of the Forest Conservation Act 1980. So, my lord, Shishuakara, there are 2 points. Number 1, community land. Number 2, uncultivated hill land. And number 3, it is the forest land. May not be reserve forest, may not be the village forest, but it is the forest, for which there is already in principle approval of the government of India for its diversion under section 2 of the 1980. That is why, my lord, it was covered by the benefits under chapter 9 of the RNR policy 2008. This is the answer. So, my lord, the example is not really correct. Now, my lord, the second argument is, which is factual once again, that the writ petition is liable to be dismissed on the ground of having been filed after inordinate delay. I will deal with this. Now, my lord, the following dates are important. Firstly, the approval of the award by the government. The date of the approval is 23rd January 2019. The dates are not disputed. 23rd January 2019, the government gave its approval of the award, annexure P4 of the writ petition. Thereafter, my lord, the Deputy Commissioner, Lower Dibang Valley, by his letter dated 4th March 2019, formally communicated to the NHPC the approval of the award. The letter is dated 4th March 2019. It is annexure 5 of the writ petition, page 50. So, my lord, we got all the relevant documents, including the award, by the forwarding letter of Deputy Commissioner on 4th March 2019. Now, my lord, when was the writ petition filed? The first writ petition. The first writ petition was WPC 182 AP of 2019. 182 AP of 2019. It was filed on 25th June 2019. Where was the delay? In a case of this nature where PSU is involved, my lord, it takes some time at least. 25th June is not too late in the day from 4th March 2019. So far as the writ petition is concerned. So 25th June 2019, WPC 182 AP was filed. Now, my lord, the circumstances under which WPC 182 AP was withdrawn with liberty have already been, my lord, stated in the writ petition, in the present writ petition. Even then, my lord, I am giving the gist of these facts. The writ petition 182 AP was withdrawn with liberty on 23rd October 2019. That is the date. Now, reasons for the withdrawal, my lord, we have already given in our interlocutory application 167 of 2019, and the relevant details are in para 29 of the present writ petition. In para 29, we have stated of our writ petition.
Yes.
After withdrawal of the writ petition with liberty, because it was withdrawn with liberty because the government of Arunachal Pradesh had already agreed to reconsider and review its own awards. There were total 4 awards. One was Dibang Valley, the main project, involving 1,600 crores. The second one was involving Lower Dibang Valley to the tune of around 335 crores. The third one was at Injonu, and the fourth one, the present one, at Bhishmak Panar. So government had agreed in principle that we will reconsider and review our own award, and we will make the fresh calculation. So it was on that, there was a meeting also was held. I have given details of that in my writ petition. Pursuant to that, we withdrew our writ petition on 23rd October 2019 with liberty. Immediately thereafter, keeping up with its assurance, the government of Arunachal Pradesh on 20 December 2019 rescinded all the 4 awards. All the awards were rescinded by the government of Arunachal Pradesh on 20th December 2019, Annexure P11 of the writ petition. Once they rescinded the awards, with assurance now we are going to reconsider everything, there was public outcry. As a result, my lord, by another order dated 24th March 2020, they recalled the order of rescinding the award. On 24th March 2020, the award earlier were rescinded. Annexure P12 of the writ petition. Annexure P12. Now, my lord, 24th March 2020 is a very big day. It's a very big day for another reason. Because, my lord, from on 25th March, the very next day, a big event took place. A big event which is now practically is a part of history. The lockdown, nationwide lockdown, on 25th March itself. And thereafter, my lord, everything had gone haywire. Even the facility of digital submission of a writ petition, etc. I remember everything had gone haywire. Finally, my lord, on 11th September 2020, we filed the new writ petition WPC 242 on 11th September. And I had appeared through video. Because prior to that, even the system was not in place over here. So, my lord, under these circumstances, the present writ petition was filed. The present writ petition is a continuation.
Whether the order passed by the Supreme Court in the case of Somoto writ petition,
Yes, my lord.
it is covered.
Yes, that is how it is. Not only because otherwise, my lord, there was no physical filing, in fact. It was the digital filing, and initially, my lord, there was no facility in the Itanagar bench. There was tremendous confusion because March 2020, my lord, it was the first phase of COVID. The proper system was not in place anywhere. So in any case, my lord, the second writ petition is a continuity of the process which started during the first writ petition. The first writ petition was withdrawn with liberty.
That's all right. That period will be covered under
That is
section
it.
14 of the.
Yes, either way. So this is it, my lord. It's a continuity of the process. So, my lord, this is the second argument. There is no delay, my lord. This is our submission. Now, my lord, the third argument. They have also argued, well, section 74 of 2013 Act provides for an appeal. Why didn't you file an appeal? Now, my lord, I ask myself, have they really followed anything stricto sensu? So far as 2013 Act is concerned, loosely, only the principle of compensation assessment was followed. There was no acquisition proceeding under 2013 Act. The acquisition proceeding was under Regulation 10 of 1947 regulation. Loosely, the principle of compensation assessment was followed under 2013 Act, followed by the brought in Chapter 9 of the RNR Policy 2008, bringing in that very part of the calculation. So, my lord, it was hybrid or more than the hybrid kind of a mechanism they followed. There was no acquisition proceeding under 2013 Act. So, therefore, my lord, apparently the appeal did not lie under Section 74. The nature of the case is such that barring writ petition, we had no other choice. We had no other alternative. That no other remedy was effective.
Yes.
Now, my lord, I turn to the quasi-legal part. It was argued that the USF has not been defined, that Arunachal Pradesh is a tribal state, a very picturesque, my lord, and a graphic description was given that my lord may look through the window, my lord will find forest everywhere, etc., etc. The people are forest dwellers. The attention of this honorable court was drawn to the Forest Dwellers Recognition of Forest Rights Act 2006 and the rights of the private parties under the Forest Dwellers Act of 2006 was highlighted. And therefore, my lord, on that basis, it was argued that even the private parties and their private land is covered by the definition of USF. Now, my lord, I have a very short answer to this. First of all, it is incorrect to say that the USF has not been defined. My lord is aware of the fact that in the state of Arunachal Pradesh, Assam Forest Regulation has been adopted. The Assam Forest Regulation, my lord, was applied to the state of Arunachal Pradesh by way of northeastern areas reorganization, Arunachal Pradesh adaptation of laws number 3 order 1974. By this, my lord, they adopted Assam Forest Regulation. Because, my lord, Indian Forest Act 1927 is not applicable to Arunachal Pradesh. It is not applicable to Northeast at all. Indian Forest Act 1927 was made by way of Government of India Act 1870. And, my lord, so far as Assam is concerned, the Forest Act 1927 was repealed in its application to Assam because of Assam Forest Regulation. This, my lord, will find in the statement of object and reasons in the Indian Forest Act. Indian Forest Act 1927, statement of objects and reasons. Last 4 lines from the bottom, just before Act 16 of 1927, the last 4 lines.
Yes.
The only other point, whether my lord has got it, the only other point which calls for further notice is the extant clause. The original act extended to the province of Assam. They are referring to the earlier Indian Forest Act, which was extended to province of Assam. But by Regulation 7 of 1891, my lord, Regulation 7 of 1891 is the Assam Forest Regulation. The Indian Forest Act 1878 was repealed as far as it relates to Assam. The bill accordingly omits Assam from the extant clause. So, my lord, the Indian Forest Act 1878 was applicable to Assam, but by Regulation 7 of 1891, which is the Assam Forest Regulation, the application of Indian Forest Act 1878 was repealed. So, therefore, my lord, Indian Forest Act 1927 doesn't cover Assam. And Assam, my lord, Assam Forest Regulation was adopted by the state of Arunachal Pradesh. By adaptation of order, my lord, that is Order number 3, 1974. It is there, Milord, they have this Arunachal code. It is called Northeastern Areas Reorganization, Arunachal Pradesh Adaptation of Laws, number 3, order 1974. Now there, my lord, will find
This order is part of the record.
my lord, number 3, order 1974 is not, but I can give a copy to your lordship. It's a law, my lord, so law, I'm just pure law I'm arguing. This one. It is there in the Arunachal code, my lord, they have the copies available easily. Just for my lord's convenience.
Okay.
Now, my lord will find in the Assam Forest Regulation, my lord will find, first of all, the reserve forest. The relevant sections are pertaining to reserve forest. Section 5. In section 5, first of all, the notification is issued by state government to constitute a reserve forest. It's like a preliminary notification. 6, followed by 6, proclamation by forest settlement officer after the publication of preliminary notification. Then, my lord, section 8, inquiry by forest settlement officer, inquiry is made. Followed by section 17, when the final notification is issued, notification declaring forest reserve. This procedure is followed from section 5, section 6, section 8, and section 17, final notification. So reserve forest, we know what is reserve forest. Through this process, a forest becomes a reserve forest. 5, 6, 8, and 17. So reserve forest, we are clear. And there are reserve forests in Arunachal Pradesh. Many. Now, in the reserve forest itself, my lord, when the preliminary notification is issued under section 5 of the Assam Forest Regulation, it becomes a proposed reserve forest. PRF, proposed reserve forest. When section 5 preliminary notification is issued. So we have proposed reserve forest and the reserve forest. Now, my lord will turn to section 29. Section 29 talks about the village forest. Assam Forest Regulation.
Yes.
Section 29. The state government may by notification in the official gazette constitute any land at the disposal of the government a village forest for the benefit of any village community or group of village communities, and may in like manner vary or cancel any such notification. So, my lord, a village forest can also be constituted. Maybe loosely it can be called a community forest, I don't know, but section 29 talks about the village forest. Now, my lord, in between the village forest and the reserve forest, there is another category of forest. Another category of forest, neither a village forest, not a reserve forest, not even a proposed reserve forest, and this is what we call loosely unclassed state forest or unsettled tracts. I'll come to this. The relevant provision, my lord, is, my lord will find, my lord will look at section 34.
Yes.
Section 34, protection of unsettled forest belonging to the government. Protection of unsettled forest belonging to the government. No person shall make use of any forest produce. I'm sorry, lordship may see in section
No. Continue.
34. No person shall make use of any forest produce of any land at the disposal of the government and not included in a reserve forest or village forest. So a forest land which is not included in the reserve forest or village forest that forest land at the disposal of the government. So without the authority of the government, no person can make use of the forest produce. This is what the section says. Except in accordance with rules to be made by the state government in this behalf or as provided by the last section of this chapter. Apparently, my lord, government has not made the rules over here. Is merry-go practically, my lord, merrily they are making use. This is how things are continuing. Nobody. But there are other relevant provisions. Lordship may also see Rule 1A. Rule 1A, my lord, because so far as Assam is concerned, in certain areas, my lord, the rules have been made. Those rules are, my lord, the pre-constitution rules. So maybe, my lord, one can argue when this forest regulation was adopted, ipso facto, my lord, those rules were also taken by the Arunachal Pradesh. I will show that. This, my lord, will find in the rule section, chapter 2, Assam Forest Regulation at page 241. I think we have the Diwan's volume, my lord. Assam Forest Regulation. This is the book. my
No,
lord.
this is there.
Okay.
Yes.
Then I don't know whether, my lord, the chapter 2 is there. My lord, may I have a look at my lord's
Yes.
code?
I think when we started, I know, we had VK Diwan. That's what we were citing.
Acha.
Are those days, VK Diwan was the only Northeast one. I think your lordship has also got
Yes,
that at that relevant time.
Yes. Yes.
When your lordship was also, the district judge also, that time we had that VK Diwan book only. We used to refer all the local acts from there itself. That was the local act. And Supreme Court Digest, that red one. Red, and nowadays is so techno, like you will get everything in your iPad.
This is no, they have not included this here. Arunachal code. I don't know, but there is no clarity. Lordship may just have a look. I'll just show for the Rule 32A. This is under Rule 32A, Chapter 2. These are pre-constitution rules. But one thing is clear, Arunachal Pradesh has not made its own rules. The trees have been provided under Rule 32A. Subsequent also, my lord, there are rules. Under 34 also, my lord will get. Lordship may turn the page. My lord will find. Under 34 also, my lord, the rules were made. Providing for specific trees, etc. This cannot be touched by anybody without the permission, government permission, etc. But one thing is certain, my lord, maybe these rules have not been taken by Arunachal Pradesh. There is a tract of forest, which is neither a village forest, nor it is reserve forest or proposed reserve forest. These are unsettled forests. It is true. London Advocate General was right in contending that there is no notification by the government of Arunachal Pradesh demarcating the USF. Obviously, they have not done it. That is why the whole exercise, the whole trouble. But we know very well there is a category of forest. So, my lord, we can safely say if the forest is not a reserve forest, if the forest is not a village forest, then it will be USF only. And USF, my lord, is a land, a forest land at the disposal of the government. And interestingly, my lord, the word at the disposal of the government has also been defined in the definition clause. That is interesting, Lordship may see. Definition clause. Land at the disposal of the government. In the definition clause, my lord will find what is the land at the disposal of the government. Section 3, my lord, is the definition clause. Section 3, subsection 8. I am sure in the Arunachal Code, the definition clause is there. Section 3.
Yes.
Section 3, subsection 8. Land at the disposal of the government. Means land in respect of which a person has acquired a permanent, heritable and transferable right of use, occupancy under any law for the time being in force, or B, any right created by grant or lease made or continued by or on behalf of the government not being land vested in the government for the purpose of the central government, whatever. So, my lord, sum and substance of the land at the disposal of the government is, it envisages a situation, and rightly so, that there may be a case where there is a forest land. It may belong to an individual by custom or by tradition, inheritable, maybe through generation, the land was with him, but there is no cultivation on that land. There is no permanent cultivation, no horticulture, nothing. It is just a forest land. That is the land at the disposal of the government, but belonging to an individual. That is why, my lord, I had a discussion with NSPC, and they are clear on this part. They said, we have no difficulty so long as if it is a forest land, the calculations are different. RNR policy, Chapter 9 comes into play along with 2013 Act. But when the land is under cultivation, then the calculations are different. Under 2013 Act, when you apply the principles of compensation, the rates are higher. The higher rates are given to a cultivation land because the values are attached to the land. Here, my lord, in this case, in the forest also there is a definition. Every tree is not a forest. Naturally grown tree is not treated to be a tree for the purpose of valuation. They do not assess the value of a tree, which is a naturally grown tree in a forest land. So, my lord, if land is not cultivated, the rates of calculation which are there under 2013 Act are much lower, but you get the benefit under Chapter 9. If a land is a community land or a village land, again you get the benefit under Chapter 9, but the valuation of 2013 Act of the cultivated land would not be applicable. So therein lies the whole difference. So sum and substance of the whole thing is, my lord, so far as the present land is concerned, we are clear about two things. Number one, it is not diverted under Section 2 with in principle approval of the Government of India under Section 2 of the Forest Conservation Act 1980. From that itself, we can come to conclusion it is not a forest land belonging to any individual. Number two, the land by its very nature, because the owner of the land say the land was under cultivation, under permanent cultivation, or horticulture plantation is also there. Their homestead are not there. For making calculation, they have taken into consideration the cultivation part. So, my lord, by its very definition, it cannot be called a forest land. It is not USF at all. There are two significant aspects. Now, my lord, lordship may also turn to the Forest Dwellers Act. Now, my lord, I am on the RNR policy. It is not a forest land, there is clarity. If it is not a forest land, my lord, they are not covered by Chapter 9 of RNR policy 2008. The only issue which is left is whether the benefit of RNR policy 2008 can be given to an individual owning a land under cultivation or which is under horticulture. Now, my lord, RNR policy, my earlier submission was RNR policy is very clear on one part. Number one, it is RNR policy deals with the calculation of compensation when there is a diversion of common forest resources belonging to a community. This is my submission, and this is very apparent from Chapter 9. And so far as the Forest Dwellers Act of 2006 is concerned, my lord, it equally deals with that aspect. Because when, my lord, forest rights are not settled, it is in the unsettled track and there is no clarity, and it is a forest land, then, my lord, a community is entitled to enjoy the resources of the forest. I will just draw your lordship's attention to some of the provisions of the Forest Dwellers Act. Lordship may see the definition clause, Section 2D. Forest Dwellers Act.
Yes.
Section 2D, forest land. Forest land means land of any description. Land of any description falling within any forest area and includes unclassified forest. It uses the word unclassified forest also. Undemarcated forest, existing or deemed forest, protected forest, reserve forest, sanctuaries and national park. Any forest land. Then, my lord, will see Section 6.
Yes.
Section 6. It deals with the vesting of forest right in forest dwelling scheduled tribe. The Gram Sabha shall be the authority to initiate the process for determining the nature and extent of individual or community forest rights, or both, that may be given to the forest dwelling scheduled tribe and other traditional forest dwellers within the local limits of its jurisdiction under this act by receiving claims, consolidating and verifying them, and preparing a map delineating the area of each recommended claim in such manner as may be prescribed for exercise of such rights, and the Gram Sabha shall then pass a resolution to that effect and thereafter forward a copy of the same to sub-divisional level committee. Such and such the whole procedure. I'll come to the point why I'm showing this. Subsection 5. The state government shall, section 6, subsection 5. The state government shall constitute a district level committee to consider and finally approve the record of forest rights prepared by the sub-divisional level committee. Below, the purpose of showing the same thing is, since learned Advocate General emphasized on the provisions of the Forest Dwellers Act 2006. Now, my lord, the Forest Dwellers Act 2006 also envisages as to how the forest rights are vested in the forest dwelling scheduled tribes. The question I'm asking myself is whether the provisions of the 2006 Act have been followed by the state of Arunachal Pradesh in formally vesting scheduled tribe rights over the people of here in Arunachal Pradesh. The answer is no, they have not done it. The entire procedure has been delineated in section 6 onwards. How you vest the forest right? Merely by saying 2006 Act is there, we are the forest dwellers, we live in the forest, etc. would not do. You have to vest the forest right in the scheduled tribes. You have to follow it up. So, my lord, in the case of reserve forest, there is a clarity. Village forest section 29 is there. But if you want to vest the forest rights from the people, under the Forest Dwellers Act of 2006, the unsettled forest in the state of Arunachal Pradesh have to be demarcated and the areas have to be delineated. They have not done it till date. But, my lord, this would not affect my case at all. They might not have done it. I am very clear. Number one, the land is not a forest land. And number two, under section 2 of the Forest Conservation Act, there is no diversion also. So either way, it is not a forest land. 2013 Act has been actually applied. They are not entitled to the protection of Chapter 9 of the 2008 policy. Now, my lord, I will only touch upon my submission, namely that Chapter 9 of 2008 policy governs only the diversion of common forest resources and compensation to the community. In this connection, my lord, a very novel argument was made by learned Advocate General, saying that, I would rather say digressing from the very definition of community. The learned Advocate General said the community is a collective of individuals. Community by itself is not an abstract entity. There are individuals in the community, so the collective whole of the individuals is a community. My lord, I ask myself, every single nation state in this world coming together constitute one United Nations. Does it mean we can say that every single nation state is a United Nation? Individuals, my lord, when they come in a group, they make a crowd. Does it mean individual is a crowd and crowd is an individual? The argument, my lord, I am sorry to say, leads us nowhere. Community is community, individual is individual. Certainly individuals will be within the community, but individuality is a separate identity. Community is a separate identity. And here we are dealing with the wealth. The moment, my lord, so long as, my lord, it is a forest land, and there is no individual right vested in the, there is no individual right in the forest land. In such a situation, community can certainly enjoy the resources, common forest resources. But the moment, my lord, cultivation comes in, it is a personal wealth. Nobody can ever argue a land which I am cultivating, that land under cultivation is the resource of the community. It is not. It's a personal wealth. Tunku Pulu here, my lord, is making a claim for himself, not for the community. Not like Sishu Ataya case. Money will not go to the chieftain. The money will go to Tunku Pulu only. It will not go to his clan. It is for his own enjoyment. So, my lord, the land we are clear, it is a private land, plain land, having permanent cultivation since time immemorial. I am using the words of the writ petitioners. The land is also not an unclassified forest within the meaning of section 2D of the Forest Dwellers Act. Likewise, the petitioners are not forest dwellers within the meaning of section 2.0 of the Forest Dwellers Act. Section 2.0 also may kindly be seen, my lord. They are not forest dwellers. Section 2.0 defines forest dwellers.
Yes.
2.0 reads, my lord, other traditional forest dweller means any member of community who has for at least 3 generations prior to 13th day of December 2005 primarily resided in or who depend on the forest or forest land for bona fide livelihood needs. The cutoff is 31st December 2005. There is no material on record. They are saying since time immemorial, their land is under cultivation. And my lord, their homestead is not on this land. Homestead is elsewhere. They themselves don't say that we are forest dwellers. There is no presumption in favor of scheduled tribe of the state of Arunachal Pradesh that all of them are forest dwellers. We all know, my lord, many of them are living in cities and towns. And in any case, my lord, the nature and extent of petitioners' forest rights have not been declared under section 6 of the Forest Dwellers Act by any mechanism of the state government. Therefore, my lord, every land in Arunachal Pradesh can't be treated as forest land. Certainly, my lord, here in Itanagar, Nahar Lagoon, these are not forest lands. We have got many towns in Arunachal Pradesh. Now, my lord, the fifth contention. Community, individual are one and the same thing. Though I have already explained it, even then, my lord, I'll just give some more clarity on this. Lordship may see in the definition clause, section 2C, common land. It is, my lord, in Arunachal Pradesh, Land Settlement and Records Act 2000. On the last occasion, please. On the last occasion, I had given the whole set to your lordship. Arunachal Pradesh Land Settlement and Records Act 2000. Yes, the other day when I was arguing,
This one?
Arunachal Pradesh Land Settlement and Records Act 2000.
Yes.
Yes. Lordship, see 2C, common land.
Yes.
Common land means any land used or reserved for the common use of a community or a village. The land of Tunku Pulu under cultivation is not for the common use of the community or a village. It is his personal wealth for which he is seeking the compensation. Likewise, section 2D. 2D community. Community is also defined. If individuals are community, may not certainly no need to define. Community means residents of a village as a whole. As a whole, residents of a village. And includes a clan, subclan, kindred. This is what. Likewise, my lord, section 2A in the Forest Dwellers Act, Forest Dwellers Rights Act 2006. They have defined community forest resource. Section 2A. Forest Dwellers Act 2006. Section 2A.
Yes.
Section 2A, community forest resource. It means customary common forest land within the traditional or customary boundaries of the village or seasonal use of landscape. In the case of pastoral communities, communities have to be pastoral, my lord. We know the pastoral community, my lord, they move from place to place. They are food gatherers, pastoral. We have pastoral tribes in Andaman and Nicobar. Pastoral tribes are there in Andaman and Nicobar, Sentinelese, Ongis, etc. They are food gatherers. They survive by hunting. They use forest resources. Within the traditional or customary boundaries of the village or seasonal use of landscape in the case of pastoral communities, including reserve forests, protected forests, and protected areas such as sanctuaries and national parks, to which the community had a traditional access. So, my lord, community forest resource has been defined. Then, my lord, likewise, section 4, subsection 1 of the Jhoomland Regulation 1947. Jhoomland Regulation 1947. My lord, in my writ petition, it is already there. I have annexed the entire regulation 1947.
Yes.
Section 4, subsection 1.
Yes.
A customary right to Jhoomland shall be deemed to be established in favor of a village or a community when such village or community has enjoyed the right to cultivate or utilize such Jhoomland for not less than 5 years prior to making of this regulation. So, my lord, distinction is made. Then, my lord, subsection 2. A customary right to Jhoomland shall be deemed to be established in favor of an individual cultivator. So, we not a clear distinction by lawmakers between community and individual. As to when a customary right to Jhoomland shall be vested in community under subsection 1, and when a customary right to Jhoomland shall be deemed to be established in favor of an individual cultivator. Both have been different. But anyway, my lord, here the definition of a Jhoomland makes it very clear. A Jhoomland, my lord, cannot be under permanent cultivation. On the last occasion, my lord, while showing my lord the definition of Jhoomland, I had clearly shown a permanent land, a land under permanent cultivation is not a Jhoomland. To that extent, my lord, the condition of writ petitioner was correct. In fact, they expressed the surprise as to how come 2013 Act was applied. It is not a Jhoomland. My purpose is to show the distinction between individual and the community. The two things are different. The lawmakers recognize this very particular fact. Likewise, my lord, para 3.1 of RNR policy 2008 defines community. Para 3.1 of RNR policy. My lord, in fact, I will give a write-up to your lordship. It's a very interesting case because whatever judgment my lord will deliver, this will have, my lord, consequences for many other cases. So, my lord, I will give my written argument also after finishing up my submissions. Para 3.1 of RNR policy 2008. May kindly be seen.
Is that page number?
Page number, my lord, will find page 82 is the policy. Page 83 is the relevant page of the writ petition. 242. Page 83 of the writ petition.
Yes.
Community means resident of a village as a whole, the clan, subclan of internet. Same definition. 3.1. So therefore, my lord, I come to my final submission. The scheme of chapter 9 of RNR policy 2008 clearly envisages that compensation for loss of USF is for the community. 9.1, column 1, 2, and 3, my lord, each of it, my lord, will find the very expression is very clear. My lord, the see at page 90, para 9.1, column 1. Payment may be termed as compensation for loss of customary rights of collection of forest produce and traditional land use of USF. Traditional land use. The Deputy Commissioner in his capacity as Forest Settlement Officer, assisted by Land Revenue and Settlement Officer, shall work out compensation for the loss of rights and privileges of tribal people to collect and use forest produce from USF at the rate of such and rupees such and such, if any rights and privileges are granted by notification constituting reserve forest for base year such and such and such. My lord, is very interesting, the last line also. Because, my lord, when I was reading Assam Forest Regulation, my lord must have noticed that not only in the case of reserve forest, but also in the cases of unsettled tracts of forest, the government of Arunachal Pradesh has to make rules. Under Forest Dwellers Act of 2006, the rights have to be vested in the tribal people. There is no notification of the government of Arunachal Pradesh in connection with that. And the last line talks about such a notification in relation with reserve forest. But there is no notification regarding the unreserved forest also, wasting of rights. But I am not on that very technicality also. It is meant for the common good, for the community. And the last para makes it clear. In addition, in case of diversion of USF, the community shall also be paid. Community shall also, meaning thereby, community is already getting the first one. In addition, community shall also be paid the compensation against extinction of the traditional rights over USF land used at the rate of 25% of NPV, such and such. The compensation to the community is over and above NPV. My lord, last time makes it clear that para 9 is dealing with the community rights. It is not dealing with the individual rights. Now, my lord, it is apparent that chapter 9 uses the word community. We are also clear about the definition of community. We also know individual and community are two different things. We also know there is no wasting of right on individuals. For that matter, there is no wasting of rights on the community either. But be that as it may, the very scheme of chapter 9 does not cover the case of the petitioner. More importantly, my lord, it does not cover the case of the petitioner because the land of the petitioner is under permanent cultivation. And it is not a forest land because there is no in principle approval of the government of India for diversion of this land under Forest Conservation Act 1980. And my lord, I make it clear that this very particular land at Bhishmak Nagar is not the part of 4577 hectare. Though, my lord, this NSPC had also written to state of Arunachal Pradesh, this document is not the part of the record. If my lord so desire, I can place it with a copy to my learned friend. The NSPC had written to Arunachal Pradesh government. It is the part of 4577 hectare. There was an RTI seeking information. And my lord, this is what Executive Director of NSPC, the Bank Project, wrote to DCF. My lord, I will refer to para 2. Letter is dated 4th December 2024. At serial number such and such of your reply, it has been stated that no forest clearance has been issued for 150 hectare land of Sishu Ataya. Sorry, sorry, it's not. This is in connection with Sishu Ataya actually. That it is the part of 4577 hectare. This land, this was never an issue at all at any point of time. It is a separate land altogether because, this land is meant for rehabilitation and resettlement of the people who will be displaced by the main project. It was in connection with Sishu Ataya. Making it clear that Sishu Ataya was part of that 4577 hectare. So there was already an approval of the government of Arunachal Pradesh. Sorry, government of India for this diversion. It was part of 4577 hectare land. This land, there is no approval, nothing. It is separate land altogether. So, my lord, with this part of my submission, practically, my lord, the issue gets settled. I need not even enter into a legal thicket, but my lord, for academic purpose, I will touch upon certain legal aspects. Because if the land is not a forest land, if it is under permanent cultivation, if there is no in principle approval for the diversion of the land under Section 2 of the Forest Conservation Act 1980, then my lord, certainly by no stretch of imagination, principles of compensation assessment under Chapter 9 can be applied. If the principles of compensation assessment under Chapter 9 cannot be applied, then my lord, only 213 survives, and we have no difficulty with that. That portion, wherein the calculation, the principles of compensation assessment under Chapter 9 have come in, that have to be excluded from consideration. That is the only thing which is there. Now, my lord, the only question would be, I don't know if it is their case, but my lord, lots of submissions were being made. May I put it this way? One may possibly argue, I do not know if exactly this is their argument, because in so many words, this was not said. Namely, that RNR policy 2008, whether such a policy can be read under 2013 Act by way of Section 103 of the 2013 Act, in addition to. Now, my lord, one may enter into legal jugglery. My lord, I have my different answer to this. But my lord, since I had discussion with the NHPC, they are very clear about one part. They said that in Sishu Ataya also we applied RNR policy. In Sishu Ataya case, since there was already a diversion of that land and there was in principle approval, we accepted that to be a forest land. It was a community land. So we applied 2008 policy Chapter 9. And we gave them the benefit under both Chapter 9 as well as under 2013 Act. So, my lord, they're willing to accept it. So, I would not really take much of my lord's time on Section 103 interpretation. Maybe my interpretation may be different, but whatever it is, NHPC concedes it in the larger interest. We have no quarrel with that. They also say, if traditionally one individual is enjoying or utilizing one particular forest land over which there is no cultivation, nothing, it is a forest land, then subject to Section 2 of the Forest Conservation Act 1980, even he may also be covered. But that is not the case over here. So, my lord, 103, I would skip it. I would not enter into legal jugglery because NHPC accepts it. They are willing to read 2008 policy under 2013 Act. In the case of USF, for the purpose of community or individual as the case may be. Then, my lord, comes another issue. Whether the cabinet resolution of May 2018 can be construed in a manner to give benefit of Chapter 9 of RNR policy 2008 in addition to the benefits under 2013 Act to those individuals whose land cannot be treated to be a USF or forest land. Again, my lord, may I, whether an individual whose land is not a forest land or a USF land and is under permanent cultivation like the present case, whether that individual can be given the benefit under chapter 9 by way of reading cabinet resolution and RNR policy 2008 together. I don't know, my lord, whether this argument, I can enter again into the legal niceties and the constitutional principles, but when, my lord, it is clear that the land is not a forest land, that chapter 9 is meant for the community as a whole, that in the present case the land is a plain cultivable land under permanent cultivation, then there is the question, my lord, of extending the benefit of the cabinet resolution. So, my lord, anyway, I'll make my submission. Firstly, my lord, cabinet resolution is nothing but the reiteration of the 2008 policy. Cabinet resolution does not say anything which is different than what is there in the 2008 policy. Assuming, my lord, my lord, if by way of cabinet resolution, they try to cover those individuals whose land is under permanent cultivation, to give them the benefit of principles of compensation assessment under chapter 9 of RNR policy 2008, then in that case, my lord, there would be difficulties. And difficulties are as follows. Section 107, my lord, lordship may kindly see. Now I'll turn to this legal argument
107
of the 2013 Act. There is a clear distinction between 107 and 108. Lordship may see section 107. Power
Yes.
of state legislatures to enact any law more beneficial to affected families. This is the heading. Then nothing in this act shall prevent any state from enacting any law. Now pausing here, my lord, lordship may see, enacting any law to what? To enhance or add to the entitlements enumerated under this act, which confers higher compensation than payable under this act, or, well, here first of all I will stop before traveling to or make provision. It's a disjunctive or, I'll clarify this. The purpose of section 107, my lord, from the plain reading is the plain purpose, my lord, from the plain reading of section 107, the purpose is within the 2013 Act itself, state by law can make provision to enhance or add. It is not making of a separate law altogether. Section 107 simply says within the 2013 Act itself, you are making a separate provisions to enhance or add, or to make provision for rehabilitation and resettlement more beneficial. So you are not traveling beyond 2013 Act. Within the Act you are doing it. It is within the Act. May not similarly to our CRPC or now Nagrik Suraksha Adhiniyam, Manor knows very well, in CRPC, many states separately have made their own laws within the CRPC itself. For example, anticipatory bail. In the state of UP, there is no anticipatory bail. They have omitted that. Reason is simple, my lord. The parliament has given this power to state legislature under section 107 because, my lord, if this power is not given under 107 and the state tries to make some alteration or change, tries to bring in its own law, the state can do it, my lord, because concurrent list is there. This power to legislate So far as law of this nature is concerned, it's traceable to entry 42 of the concurrent list. The list 3. It is entry 42. Lordship may see the Constitution. Entry 42. Both state and center has the power. I will come to Article 254 thereafter. Repugnancy would arise. 7th schedule. Entry 42. 7th schedule. List 3. Concurrent list. Because, there are several judgments. Compensation has been treated to be the integral part of the power to acquire, acquisition and requisition. The power of acquisition and requisition, my lord, is integral to power to compensate.
Yes.
It is entry 42. So, my lord, both the state and center has the power. Now, Lordship knows very well, the center has made the law in exercise of power under entry 42 of the list 3. So once, my lord, law is made by the parliament and section 107 does not empower the state to add something into it to give more benefit to its people, then the state will not be able to do it because of Article 254. Repugnancy would come in. My lord is familiar with that. Assent of the president would be needed. You can't do it because the law of the parliament shall prevail over the state. So 107 is within the 2013 Act itself, you can add something more, enhance or add, or make provision. That has to be by way of law. You can't do it by executive power. This argument supposedly, because the law 2008 policy does not trace its validity or validation from 2013 Act. The power to make policy RNR policy 2008 was vested in the state by way of the national policy of 2007. Certainly, my lord, the 2008 policy for its validation cannot look for 2013 Act. 2013 Act will not travel backwards to validate 2008 policy. It is the cabinet resolution of May 2018. May 2018 cabinet resolution came after 2013. So one may argue that since executive power is coextensive to legislative power, the state may not have made law under 107 in terms of the scheme of section 107 to enhance or add within the 2013 Act. But cabinet resolution is there. We have the executive power, we can do that. To that, my answer would be that exercise of executive power would be circumscribed by a law of parliament, which is 107. To this, my lord, the case law that I am citing is my esteemed colleague would be familiar, the Vishambar Dayal. I am sure he must have seen it. Vishambar Dayal versus the state of UP. The proviso to Article 160T would circumscribe that power because it would go contrary to the law of parliament, section 107. 1982 1 SEC, page 39. My lord, for a moment, we can always see the proviso to Article 163. But anyway, let us see the case law.
Yes. Repeat the citation.
The citation is 1982 1 SEC, page 39. Page 39. The paragraph is para 22. Oh, there is a mistake. I'm sorry. Para 22. Para 22. The last 4 lines from the bottom.
Yes.
The last 4 lines from the bottom. This is of course subject to the limitation contained in proviso to Article 162, which directs that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by the Constitution or by any law made by Parliament upon the Union or authorities thereof. 162 proviso may kindly be seen for a minute. That is beside the Taylor versus Taylor. Subject to the provisions of this Constitution, the executive power of the state shall extend to the matters with respect to which the legislature of the state has power to make laws, provided that in any matter with respect to which the state legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. The law Parliament has already made, my lord, on this very subject. This is what I am saying. The law Parliament has already made, 107 is already there. Now, by way of a Cabinet Resolution 2008, you cannot bring something into it without making a law. And that law has to be a law legislated by the state in terms of Section 107. Another thing, my lord, with more clarity, my lord will find in Bharat Cooking Coal case, 1990, volume 4 SCC. Page 557. The relevant para 19. It is elaborated so as to give more clarity to this very proposition. Relevant page 575. The relevant portion, my lord, is at placitum H. Page 575 SCC, placitum H.
Yes.
Moreover, fourth line from the bottom, moreover. Moreover, the proviso to Article 162, whether my lord has got it?
Got it.
Yes. Moreover, the proviso to Article 162 itself contains limitation on the exercise of the executive power of the state. It lays down that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of a state shall be subject to limitation of the executive power expressly conferred by the Constitution or by any law made by Parliament upon the Union or authority thereof. The limitation is contained in the proviso to Article 162 was necessary to avoid conflict in the exercise of executive power of a state and the Union government in respect of matters enumerated in list 3 of the 7th schedule. If Parliament and the state legislature both have power to make law in a matter, the executive power of the state shall be subject to the law made by the Parliament. The executive power shall be subject to the law made by the Parliament or restricted by the executive power of the Union expressly conferred on by the Constitution or any law made by Parliament. Parliament has made the law. Parliament has told you how to do it. State by law, they say. The mandate is very clear. Enact, we all know the meaning of enacting the law. What is enacting the law? I will come to the other articles. Example was given of Article 16.4. That example was misconceived and misplaced. I will show why. From Indrasani judgment itself. The Supreme Court clarified that. Reservation one can always make by executive power. Because that is service belong. Reservation for what? Reservation in the jobs of PSU, in jobs of local bodies, in state, in center, everywhere, even in the NHPC. Certainly not by office order, by administrative order, they can make reservation. Justice Sawant's judgment, my lord, will see in the Indrasani case, Justice Sawant very clearly said The rules, service rules are made under proviso to Article 309 of the Constitution. So therefore, the power vested in you under Article 16(4) to make reservation, you can do by an exercise of executive power. A parliament is not required to make a law, or a state is not required to make a law. Executive power can be exercised because it is service. Reason is simple. Because you require reservation even in the local bodies, municipality, NHPC, PSU, they're all there. So executive power is enough. In the case of PSU, office memorandum, office orders would be good enough to make a reservation. We don't require to legislate on that. I'll come to that later on. Now, just better I clarify. Indra Swami Lordship may see 1992 Supply 3 SEC 212. 1992 Supply 3 SEC 212. The judgment of Justice Sawant, relevant portion at para 546.
Ada?
Para 546. Page would be allowed in SEC. There is a mistake. Just a minute. Para or page. Whose book you have given me? Okay. Lordship will see para 546. Yes, at page 557.
Got it.
The language, may I read, my lord? The language of Article 16(4) is very clear. It enables the state to make a provision for the reservation of appointments to the post. The provision may be made either by an act of legislature or by rule or regulation made under such act, or in the absence of both, by the executive order. Executive order is no less a law under Article 13(3), which defines law to include, among other things, order, bylaws, and notifications. The provisions of reservation under Article 16(4) being relatable to the recruitment and conditions of service under the state, they are also covered by Article 309 of the Constitution. Therein lies a catch. Article 309 expressly provides that until provision in that behalf is made by or under an act of the appropriate legislation, the rules regulating the recruitment and conditions of service of persons appointed to services under the union or the state may be regulated by rules made by the president or the governor, as the case may be. Further, wherever the Constitution requires that the provision may be made only by an act of the legislature, the Constitution has in express terms stated so. This is equally important. I read again. Further, wherever the Constitution requires that the provision may be made only by an act of the legislature, the Constitution has in express terms stated so. For example, the provisions of Article 16(3) speak of the Parliament making a law, unlike the provisions of Article 16(4), which permit the state to make any provision. Similarly, Article 302, 304, and 307 require a law to be enacted by the Parliament or a state legislature, as the case may be. This is my second argument, my lord. If we have to read other articles, read Article 300 capital A. No person shall be deprived of his property save without the authority of law. The Parliament has, the founding fathers and series of Supreme Court judgment, it is clarified, save without the authority of law. The authority of law is the law enacted by legislature. It cannot be made through an executive order. Likewise, Article 300A, Article 304 also, the same scheme is there. Article 19 example is misplaced. Article 19 is not freedom of speech and expression. I am a government servant. I don't have the freedom to abuse my senior. I can't do that. That would be insubordination, indiscipline. For that, a law enacted by Parliament is not required. One can issue an office order. Assembly, taking out procession without the permission, one has the right to assemble, fundamental right. But that right can be checked and curtailed. Context. Learned Advocate General was right. Context is relevant. Yes, context is relevant. That is why in Article 19 also, my lord will find clause 2 to clause 6. Expression is very clear that law would be law within the meaning of Article 13. that law would not be a law enacted by a parliament or by a state legislature. Here 107 says, state shall enact a law. State enacting a law has a meaning. It can't be an executive order. The reason is simple, repugnancy Article 254. Because you have been given the power by the parliament to do it in this way, and Taylor versus Taylor principle will come here. The statute clearly provides for doing things in a particular manner, it has to be done in that manner or not at all.
Okay, we will resume after 5 minutes.
Oh, I'm sorry. I'll complete, I won't say much.
5 minutes?
Sorry. Yes, I'll finish. The same proposition at para 41. I will not read it, my lordship may just take note of that. Article 300 capital A, the law has to be the law enacted by parliament. It can't be by executive power. Vishwambar Daya, para 41. So far as my lord,
Yes.
Article 304 is concerned, the same proposition. It has to be a law made by parliament, not by executive order. It is State of Mysore versus Sanjeevaiah, AIR 1967 Supreme Court, page 1189. Relevant page 1192. In my write-up, I will quote that. The purpose is that, here, the plain meaning is very clear of 107, enacting a law. Legislature is in the heading. Inside, the provision says state enacting a law. So meaning is very clear. So it has to be a law by the state. But law would be for the purpose of enhancing or adding or making a provision under 2013 Act itself. So my whole submission is, if a state wants to do it, it can very well do by enacting a law for particular people. And there are lots of judgments that if there is some doubt regarding the wording or the meaning, then help can be taken of the heading in the interpretation of statutes. Lordship will find state enacting a law. Enacting a law can't be an executive order.
No, this second part, or
Making
or
provision.
make provisions.
Making provision means not legal provision, making provision. Making room for something else, rehabilitation and resettlement. That provision is that provision. The meaning of the expression of making provision or making provision, or is significant for the purpose of rehabilitation and resettlement, or is for that purpose, or is not for purpose. Significance of or is for the purpose of rehabilitation. Significance of or does not lie in provision. Provision has two meanings. One is the provision in law. We know it very well. Please make provision for that. Please make provision for ration. Please make provision for the food grains. That is also a provision.
No, that's all right. On the other day,
To 108. That is why 108 will make it very clear. Thereafter, we have to read 108. Now 108 I just turned to. Lordship may see 108. What is the difference between the two sections? See 108. Option to affected families to avail better compensation and rehabilitation and resettlement. It reads, where a state law or a policy framed by the government of a state provides for a higher compensation than calculated under this act for the acquisition of land, the affected person or his family or member of his family may at their option opt to avail such higher compensation and rehabilitation and resettlement under such state law or such policy of the state. Now, my lord, what is the significance of the subsection 1? The significance is, my lord, The law we are talking here, or the policy we are talking here, it is totally, completely independent of 2013 Act. It is not within the 2013 Act, it is independent. It can be RNR policy, total, or it can be a law enacted by a state. My lord, 108 subsection 1 was necessary because had 108 subsection 1 not been there, because of repugnancy, there would have been difficulty, 254. So Parliament has specifically given the power to the state, delegated the power to the state. You can either make a policy or you can make a law. Policy can be by an executive order. Or make a law. For what? Totally independent than 2013 Act. Totally different. Then the option is there. You can exercise the option. If the people say, no, we will be covered by that policy or by the state law, you will be covered by that. Or if they say no by 2013, you will be covered by 2013. That is not the case with 107. 107 within the 2013 Act, enhance or add or make it provision. This we have to do by law. Because within the 2013 Act, you are tinkering. You are making some changes here. Or carving out an exception. How do you do it? Unless you exercise the legislative power or you do what 107 tells you to do. That is the purpose of the law. Provision is not that legal provision. Provision is making, it's a literary meaning provision over here. Or make a provision. You know, there are two words, law, policy. There is nothing like, the moment we use the word making provision, we use the word making provision in a literal sense. Making provision can never be in the legal sense. In the literal sense, making a provision for rehabilitation and resettlement. But that has to be by law. This is what I'm saying. Provision has a literal meaning over here, not a legal meaning. It is law enacted by a state. It has no other meaning. Option, section 108, it has to be independently either by state law or by policy. That could be an executive order. But it would be something separate than 2013 Act. It's an enabling power. Parliament has given to state or executive. But then in that case, option will be exercised. Which one you want to be governed by? Likewise, subsection 2, it is again for rehabilitation and resettlement. Where a state law or a policy framed by the government of the state offers more beneficial, same thing, independent of 2013 completely. Because 2013 law also provides for rehabilitation and resettlement. So below, a distinction between 107 and 108 makes it very clear. 107 is within the 2013 Act. 208 is outside the 2013 Act. That is the distinction. If within the 2013 Act you want to make a change, you want to carve out an exception, you want to make a separate provision, you do it by enacting a law to that effect. You know, this is further buttressed. There is one judgment I could find of a high court, Bombay High Court, in Mario Kota's division bench, where 107 was looked into by the court. How the courts have looked into 107, my lord will find from this division bench judgment of the Bombay High Court. Don't create confusion. I'm sorry, I have to, I'll give you 2022 SCC online, Bombay 1743. The case came from Goa, my lord, here. The relevant para is para 106, 107, 108.
Yes.
Section 106, they have referred to section 103. I'll just read that also. Section 103 of the 2013 Act provides that the provisions of this Act shall be in addition to and not in derogation of any other law for the time being in force. The Honorable Supreme Court has already explained the impact of a similar clause on the issue of repugnancy in the case of Forum for People's Collective Efforts. In any case, the existence of such a clause is not a license for the state legislature to enact a law on the subject in the concurrent list, which is in direct conflict with the parliamentary law on the same subject. Therefore, to avoid a construction that might have enabled the state legislatures to whittle down the benefits of the 2013 Act, the Parliament made specific provisions in section 107 and 108 of the 2013 Act. But this is what I was submitting before my lord. Section 107, section 10, para is also 107. Section 107 explicitly empowers the state legislature to enact any law more beneficial to affected families. This section provides that the state can enact any law to enhance or add to the entitlements enumerated under the 2013 Act, which confers higher compensation than payable under the 2013 Act. Similarly, section 108 gives an option to avail of better compensation where higher compensation is provided under the state law or policy framed by the government of the state. The provisions of section 103, 107, and 108 therefore provide that nothing contained in the 2013 Act shall prevent the state from enacting any law to enhance or add. Same repetition and same explanation, my lord. This is one division bench. And lastly, my lord, I will only, my lord, because on calculation I had given my lord write up to your lordship about the system to be followed and all. There is only one interesting aspect on the calculation part, because there was controversy on that, namely on the calculation of interest. Because my lord, on that there were divergent views. There was one school of thought which believed that the interest can be calculated before the solitium, and thereafter solitium should be calculated. In this very case, the interest was calculated before the solitium. Then solitium was broken. My case is first solitium, thereafter interest on the solitium. This is how it should be. On both the divergent views, my lord, they are considered by the Supreme Court in Sundar versus Union of India, 2001, 7 SEC, page 211. Constitution bench. There the Supreme Court made it very clear. It should be after the solitium. The relevant paragraphs are para 2, para 4, para 5, para 6, para 8, and para 26. I will only read para 26, my lord, because in para 26, the Supreme Court, my lord, affirmed the view of the division bench of the Punjab and Haryana High Court in the words used by Punjab and Haryana High Court, Justice S. Sandwaria. Supreme Court said this is the correct principle. At page 231.
Yes.
Page 231, para 26. We think it useful to quote the reasoning advanced by Chief Justice S.S. Sandwani of the Division Bench of the Punjab and Haryana High Court in the state of Haryana versus Kailashpati. Once it is held, as it inevitably must be, that the solitium provided for under section 23, subsection 2, may not article of the old Act, 1894 Act, of the Act forms an integral and statutory part of the compensation awarded to a landowner. Then, from the plain terms of section 28 of the Act, it would be evident that the interest is payable on the compensation awarded and not merely on the market value of the land. Indeed, the language of section 28 does not even remotely refer to market value alone, and in terms of tops of compensation or the sum equivalent thereto. The interest awardable under section 28, therefore, would include within its ambit both the market value and the statutory solitium. It would include both the market value and the statutory solitium. It would be thus evident that the provision of section 28 in terms warrant and authorize the grant of interest on solitium as well. So first you calculate the solitium, then the interest at last, the component. And the rest of the things I quote, so far as calculation sequence is concerned, it is mandated by the Act itself, the calculation sequence. So basically, the whole thrust of my argument is very simple without entering into the legality. My basic summation is the land in question is not a forest land. It is not a community land. It is permanently under cultivation. It does not even fulfill the definition of a homeland. So no question of entering into cabinet resolution, RNR policy 2008, interpretation of the constitution, section 107, 108, all the ticket we need to enter into. RNR policy 2008 is out, cabinet resolution is out. They are entitled to the benefits under 2013 Act, plus corrective measures to be taken for calculation of the compensation in the correct sequence. That is all. Broadly, this is my case.
No, that's all right. On the other day, Mr. Das has argued that as per that schedule also compensation has not been calculated.
As per,
Schedule.
no, it should be followed, that's all. The mandate
My lord,
has to be followed.
If that be the case,
Yes.
my lord, mandate, see, my learned friend is very clear on that part. Section 29 has not been followed. Now, what if you are finished, my learned friend, what I have understood, what my learned friend is saying, I'll take 5 minutes. He's saying that you don't get a benefit under the RR, the Rehabilitation and Resettlement Policy of 2008. That's what I've understood. He said, if it is a private land, you get all the benefits under LARA Act. No one can deny it. Benefit under 2013 Act. That's what I have understood, my learned friends. So that your lordship doesn't have to trouble yourself to go into 103, 107. Only when it goes 107 on 107, it is only a case where Rehabilitation and Resettlement Policy is attracted in my case. That's what I have understood,
Yes,
my learned friend.
That's my case.
That's what I have understood, my lord. So if that be the case, there are two propositions. Here, number one, I have argued one, namely that it is also I should get the benefit of Rehabilitation and Resettlement Policy of 2008. I did not go further into other aspect of the matter. On the last occasion, I have dealt also, I have read what is Jumeland Regulation 1947, how I am covered, what is individual, what is community, that part already I have dealt. And I don't want to repeat further on this point, on this issue. What is most important, interesting, I have seen that during the course of deliberation, my learned friend has given one, so far as Sishoata's case. My learned friend has started with the opening sentence, opening case in respect of Sishoata, which was indicated in my writ petition, page 309. Your lordship just recollect that. And what we said, that maybe a community. And we said, not only the benefit doesn't get to community, it gets to an individual, it gets to a clan. Now, the argument which was advanced was by us, was that net present value has been calculated, and in that case, there was no diversion of forest land. Now, today, my learned friend,
There is diversion. Again,
no,
I've clarified.
my learned friend has
There is
clarified, my learned friend has clarified with a letter. Kindly see this letter. This letter, today he has produced. One letter. Kindly see there is a diversion of forest land. This letter has been on 4/12/2024. Yes. Now this, kindly see the RTI, which we made an RTI on 25th of November 2024. Kindly see that RTI. And that reply, they have given to Deputy Commissioner on 4/12/2024. Kindly look into the dates. This is 25th of November 2024. Clearly, sir, please refer to the RTI application received in this office, information pertaining to 150 hectares acquired by state government so and so, Shishoatia, Lower Dibang Valley, Arunachal. A. Furnish the detail whether forest clearance is issued for acquiring 150 hectares of land in Shishoatia. If yes, furnish detail no. That means indicating there was no forest clearance. Number B. Furnish the details whether 150 hectares of land as Shishoata falls within notified forest area or not. If yes, furnish the detail no. C. Furnish the detail whether the funds have been allocated by the user agency for diversion 150 hectares of land as Shishoata for DMP project. If yes, furnish the detail. If no, please state reply as no. Does not arise in view of serial number 1A. So indicating thereby, this is 25th of November 2024. That's why we made an RTI. And our instruction was there is no diversion of forest land. So if there was no diversion of forest land, what is indicated, there has to be a diversion of forest land to get the benefit of 25% net present value. That was the case. Now, we made an RTI and we said that there is no diversion. Here also, where there is no, they have indicated clearly. Only there is a reply on 4/12/2024, which was handed over to this court and said that 150 hectares falls with 4577.84 hectares. The information goes, my lord. This does not fall under 4577. That's my information. Now the government has to say whether it falls or not. Whatever may be the reason, we showed this only for the purpose of bringing home my case, saying that if a benefit is given to a community where there is no diversion of forest land, why we should also get the benefit of the same benefit. That's our case. My learned friend has said, we have given a benefit. One, there was a diversion, the permission has been taken, in principle approval has been taken. What I've understood, in principle approval has been taken. B, being a community land, we have given it net present value. See, USF land. This is what, but to my argument, I am advancing, saying that there is no diversion of forest land. In the issue that clearly is indicated in RTI. Number two is stated that in this particular case, where there is no diversion of forest land, be the community, being an individual, be you get the benefit. This is my reply to my learned friend. Now, my learned friend has shown one thing, that you are not entitled to get the benefit under the RR policy of 2008. You are entitled to get benefits only under 2039. Now, I have seen that there is a manual of 2022, if your lordship, because my learned friend said that standing crops and tree, kindly see under this, if your lordship kindly see the manual of 2022, which may not be applicable in the present case because it was 2018. Here is 2022. Kindly look into this. See this, my lord. Kindly look into it. 9.2. I'll just make a very clear argument on this point. This is, kindly see on the top, my lord, it is 2022 manual. Manual for land acquiring Arunachal 2022. Lordship got it? Now kindly see 9.2. 9.2. I just made a flag mark red. See on the top 9.2. Valuation of forest trees, forest produce. Lordship got it? That flag.
Page number?
That flag is page number 16, 16. Flag is there. Page 16.
Yes.
16. 9.2. I think on the next page, I think 9.2.
Yes, yes, got it.
9.2. Kindly see 9.2. 9.2. Yeah, valuation of forest trees / forest produce. The cost of naturally grown individual forest trees shall not be compensated. However, a lump sum amount for USF and in respect of notified, if any rights and privilege are granted by notification constituents, such forest shall be paid as provision of section so and so, compensate the tribal families for loss of such tribal rights and privilege over the forest. Now, my lord, what it says, that this benefit, a lump sum amount of USF in respect of forest notified area, that benefit one will get under the RR policy of 2008. Now, if your lordship kindly see next 5, next page, see 2, that is chapter 5, 2. Chapter 5, 2. That is next page, your lordship, 9.2. Then it goes on 15, now 5. Policy of unclassed state forests, 1. Kindly see 2, my lord. 2, next page 2. Kindly see next page. All kind of forest trees, forest produced, held under the USF land. So what my learned friend, these are not USF land. Shall be compensated as per the provision of section 9 of chapter 9 of RR policy of 2008 to compensate the tribal families for the loss of right over such asset. So once you come under the purview of the RR policy, which is under the USF land, so you are entitled to get the benefit under RR policy. What he's saying, you are not entitled, because these are individual, these are private land. You are entitled to get the benefit only under 2013 Act. If you see the next sentence, which my learned friend has said, the cost of naturally grown forest trees shall not be included for assessment of compensation. So once you get the benefit under the RR policy, being an USF land, so you will definitely not get the benefit of those naturally grown trees. But if I don't fall under the category of USF land and fully under the LARA Act 2013, then I am entitled to get the benefit, all the benefit under naturally grown forestry under Section 29. And my learned friend is saying, yes, you are entitled to get a benefit, 100% to get a benefit under Section 29. Because he said that your land is a private land. Your land is not fall under USF land. You don't get the benefit of the RR policy of 2008. If that be the case, my lord, then there were two arguments. If I don't get the benefit under policy of 2008, I'm entitled to get 100% benefit under 2013. So my respectful submission, last is that if that be the case, my lord, let them be, I'll be happy to be benefit under the RR policy or net present value, if it is not considered somewhere by your lordship that, but my humble request that at least I should be get benefited by all the provision that has been laid under 2013 Act, inclusive of Section 29. Now, there is no dispute. Now my submission will be, there is no dispute in respect of, my lord, the compensation of land is concerned, which around it comes about 33 crores. But rest two of the components, my lord, one is the USF land, another is 25% of net present value, which we calculated. Of course, my lord, it comes to about 42 crores when it added all these components. All these components, my lord, will kindly see once again, my lord, the components. See the writ petition 42 at page 46. Kindly see say, page 46 of 242.
Page number
46 of the writ petition 242.
Yes.
So 42 is, kindly see, my lord, they have calculated 12, serial number 12, damages additional 25% of net present value. Because why? If your lordship looks into it, a letter issued by them, put us down, no, only one second. One second, I just if your lordship looks into a 51, before that 51, after 51, that is 8/3/2019. Kindly see that. This is the letter which they have written to Deputy Commissioner by the NHPC. However, it is to inform you the award issued by under letter referred above was examined at the project is observed. Compensation as per Arunachal Pradesh State RR Policy 2008, clause number 9(3) for extinction of traditional right over use of USF land, 25% net present value has been enumerated. In this regard, it is submitted. A net present value is to be paid for the forest land of so and so plus construction facility area for which indicates land of RR at Vispanagar does not come under the purview of net present. Moreover, DFO Teju has also clearly informed that the area bounded for the said RR site is not a part of notified forest. So their whole contention when the award was calculated, they were not aggrieved by any compensation on land. What they were aggrieved that 25% net present value or USF land, that benefit should not be given to us. Today, they cannot come and say that factor is wrongly being calculated. That is not their case. Only that we are not entitled to get these two benefits. If your lordship holds that, let us put in another way, that if your lordship holds and finds that we are not entitled to get benefit under these two provisions, because the lordship's finding will be hypothetical, that after going through it, we find that the argument which is advanced by Mr. Tiwari is accepted to the extent that we don't fall under these two categories, or we don't fall under the purview of the RR policy. Of course, these two categories, except these two criteria, we are entitled to get all the benefit which has been calculated by the state. Now, that is I'm saying. Now, the admitted fact, the calculation of land today, my lord will kindly see. I am not saying that my learned friend has delayed this matter. Somehow, this way, that way, it took 2024, and we deeply obliged that your lordship has taken out the matter continuously. Continuously, whatever the end result, my lord, that's a different thing. We don't know what we do. At least we are not blaming anyone, but we have also tried. Somehow it doesn't click. So this only my humble request to your lordship that this is the amount which goes to the landowners. From 2018, they have been till today, they have not got a single penny. What my humble prayer before your lordship is, there is no dispute so far as the compensation of 33 crores, 32 crores on the assessment of land which has been made. Rest, my lord, your lordship has to decide on the net present value, whether we are entitled, or the USF land, whether you are entitled. If lordships find that we are not entitled, we agree to the submission of Mr. Tiwari. Then, of course, 29, your lordship will kindly, because this is, my lord, as beneficial, the beneficial legislation has been made for the benefit of the landowners. I'll humbly request before lordship that particular benefit should be given to us. At least they have to assess on their side, which has not been assessed by the state government, because state government didn't assess, because state government went ahead and said that we are entitled to get the benefit under the RR, the Rehabilitation and Resettlement Policy of 2008. On the basis of they have calculated. Because we cannot get both. That is why they calculate on the basis of Rehabilitation and Resettlement Policy. So my humble request before your lordship, that at least that undisputed amount, immediately they should release it. Undisputed. Your lordship is dealing the whole case. Their lordship has will decide the entire case. Now,
We are agreeable to that. We were agreeable earlier also, but petitioner was not willing to accept.
No. And today I am telling your lordship one thing. My learned friend has mentioned one matter, one particular aspect of Jitu Miri's case. There were a few other cases. My lord, that's the individual decision which they have taken. They have taken a decision to withdraw it because they have come with a hand with NSP saying that, okay, we'll compromise this matter outside the court. Not necessary that we'll compromise the matter. That is why if your lordship looks into the affidavit filed by the government, the government stated in their own affidavit, it is an individual who has decided their case. We have decided not to withdraw the case. Because in all cases, Jitu Miri cases, while they have decided to withdraw it, on the ground they decided to compromise outside the court. They said, okay, we don't want. We want certain amount to get it, and we'll come out from this case. So kindly see all those cases, my lord, that they are willing to compromise. We decided not to willing to compromise with the NSPC. We decided to go ahead with the court case. So that's what, my lord, our case is, my lord. So my request before this court is that, so undisputed amount, there is no dispute about this amount. And if your lordship hold that there is no dispute of the land, one. Number two, if your lordship holds that yes, section 29, we are entitled to get under Lara Act, so let it be calculated by the state government, reassess whatever is there on the attached land and let them pay it. And if it is an RR, also there is absolutely no problem. If it is an RR, your lordship holds that we are entitled to get the benefit under RR, because either it is not only communicated in individual under Jhum Land Regulation 1947. We have also shown what is not only definition of Jhum, we have shown explanation 2 also, how it is attracted in private case also. And thirdly, which is of course a part of the Advocate General's argument, but I just want to draw your lordship attention to last about 107. Maybe my learned friends say that may not be attracted in your case if the court holds that it is under Lara Act, just to show that 107 kindly see. 107, second part, which your lordship indicated, or make provisions for rehabilitation resettlement, which is more beneficial than provided in this act. Now, this 107 by virtue of 2013 Act came. Now, if your lordship kindly look into the statement of object and reasons, kindly see. See page 5, 8. Object and reasons, 8. Lordship got it?
Yes.
8. A national policy of resettlement rehabilitation for project affected family were formulated. Statement of object and reasons. C8. A national policy of resettlement rehabilitation for project affected families were formulated in 2003, which came into force with effect from February 2004. Experience gained in implementation of this policy indicates that there are many issues addressed by policy which needs to be reviewed. There should be a clear perception through a careful quantification of the cost and benefit that will accrue to society at large of the desirability and justificability of each project. The adverse impact on affected family, economic, environmental, social, and cultural must be assessed in participatory and transparent manner. A national rehabilitation resettlement framework thus needs to apply to all projects where involuntary displacement takes place. Now, 9. National Rehabilitation Resettlement Policy 2007 has been formulated on this line to replace the National Policy on Resettlement Rehabilitation for Project Affected Families 2003. New policy has been notified in the official gazette and has become operative with effect from 31st of October 2007. Kindly see the next. Many state government have their own rehabilitation and resettlement policy. Many public sector undertaking agency also have their own policy in this regard. So all this has been on the basis of the national policy of 2007, and on the basis of 2007, my lord, it has been entrusted to the state to make a policy, and accordingly 107 has two parts, where other part this has been given to the state to make a policy, and accordingly this policy has been made for the benefits of those people which fall under the RR policy of 2008.
Just 2013 and 2008. 2008, as I said, cannot seek its validation from 2013. 2013 Act does not travel backward, it is prospective.
But 2013, what I will submit, 2013, when 1894 Act was there, that time also national policy was there. That was there. State policy was there. They are adopting. They can't say that we don't get the benefit under the RR policy of 2000. They said in my case, it is not, maybe not be attractive, but they get the benefit. The benefit which is given under the RR policy of 2008, and that has been because of the project affected family. They want to put the project, and those projected families will be displaced and brought in my particular place. That's the whole idea.
There is no
That's-
displacement of
That's
there
that's
is no displacement. There is
then-
no homestead over
then-
there. Only agriculture.
no. You have been brought, all these people, affected people will be brought in my place.
Yes.
Then it has been acquired. It is your letter who have written to me, to the state, saying that please acquire under the forest regulation to 1947. Can you deny it?
What I'm saying.
So that's what
there
my,
is no
no, see,
displacement.
this is a never ending argument.
There is no-
This is, I just placed and I finish up my argument, and I am deeply obliged by giving such a time to both of us. My lord, here 3 days or 4 days we argue. I don't want to further trouble your lordship. I am deeply obliged.
Only one thing, let there be no
Listen,
confusion.
I am no confusion. See, my learned,
Only
the
one
court
thing.
has already recorded. This is, you say, then again I will say.
No,
That's
I'm
what I will
not.
never
I'm
ending.
Only one
That's
sentence,
never ending.
only one thing. My lord, main project people displaced. They have to be rehabilitated. If they have to be rehabilitated in the land of X, even though X has not been displaced from his land, it was agricultural land, X will say, no. You have to provide land for my rehabilitation. Then land of Y will be taken. Then Y will say, well, now then I have to be rehabilitated. So rehabilitation after rehabilitation, there could be a multiplier effect. Nobody finally, there has to be somebody who doesn't need rehabilitation. In their case, they don't require rehabilitation because they have not been displaced. It was a cultivation land. No homestead was there, my lord will find from the record. Other cases different. There's homestead was there, not given submergence. They are displaced, they have been brought here. It's a cultivation.
Only what my friend has argued, he is accepted that I should get the benefit of 2030.
Yes, agreed.
So it is agreed. If it is agreed, so section 29 also I should get the benefit. That's 29.
Yes, Mr. Tiwari, what is your reply in respect of 29?
Since we have conceded that 2013 Act applies.
Yes.
So I hope it has been correctly applied. Only the sequence is wrong. But if my learned friend says 2000, if my learned friend says 2029 has not been attracted, has not been brought in, state will look into it.
Correct.
They will do
Please.
the exercise.
That's why I know that's.
They are entitled. I can't say no to that. 29 is a part of 2013 Act. State will look into it. Whether they should get it or not get it. Because if it is cultivation, there may not be trees. If it is horticulture, that must have been counted for. I believe so. It has been accounted for.
I know he.
If there is something, natural grown trees.
Then again, an assessment has to be carried out.
Has to be.
In that case.
In that 29,
Yes.
only natural grown tree.
Yes, yes.
But what my humble prayer is that whatever undisputed, minus this, they
That
should
can be-
release it.
that can be released.
They should
Yes,
release it.
Any,
We are agreeable.
They agree. Yes.
We are agreeable.
That should be released. Your Lordship will pass the order. There is absolutely no problem in those 2 points and plus this. But they should release.
Give us some time that NHPC may consider releasing non-disputed amount.
That non-dispute.
That much. We will start the process.
and if we think that reassessment has to be done in respect of this 29, then that exercise has to be carried out within a time frame.
Yes, right. Of course. I'm deeply obliged, my lord. Deeply obliged.
Part Mr. P.K. Tiwari, Learned Senior Counsel assisted by Mr. K. Saxena, Learned Counsel for the petitioner in WPC number 242. And Mr.
Both 230 also. 230 is there in petition. 242 and 230 together.
230, you were respondent, 230. And Mr. D.K. Das, Learned Senior
My lord,
Counsel
D. Das.
assisted by Mr.
Didas.
D. Das, Learned Senior Counsel assisted by Mr. Learned Counsel for the respondent number in WPC
230.
230.
Private respondent.
And private respondent 242.
Mr. Kamdung, you are for respondent number? You are for respondent number?
In fact, my lord, I am assisting AG in this case, madam.
Oh, and also heard Mr. No, Learned Advocate General for the State of
Yeah. One written note has been prepared.
Yes, you
One
can
copy
give.
I have got. I'll give a copy to my learned friend Tiwari also there in Guwahati itself.
Some time may be given to me. I will prepare my note and I will hand over the copy to him. I will do it, Milord, as soon as possible. If
1 or
not-
2 days? 1 or 2 days?
Milord, within 2 days may be difficult. Tomorrow I have to attend a case, Milord, at the principal seat. Milord, within the week I will do it.
Within this week? Okay,
Within 1 week, 6 to 7 days I will do it.
okay.
I will see to it, Milord, at least before vacation, my lord gets it.
My lord, I have limited submission, my lord.
Ah,
In fact, my lord, extensively learned AG and senior colleagues has submitted, my lord. In addition to that, my lord, only I have cleared 2 important issues, my lord. That, my lord, first of all, my lord, in petition 230, filed by this private respondent in 240. We have filed our affidavit, my lord. In that affidavit, my lord, we have clearly mentioned that, my lord, at page number 371 in this petition 230, my lord.
In which case? 230?
230, my lord.
Yes.
Here, my lord, we have clarified our stand, my lord, stand of the government, my lord. My lord, may kindly come to page number 371, my lord. 371. This is the counter affidavit filed by the state, my lord. In writ petition number 242.
371.
Yes, my lord, page number 371. My lord is taking up writ petition number 230.
Yes, 230.
Yes, at page number 371, my lord.
371 is one affidavit perhaps. Affidavit it is.
Affidavit filed by the state in this in SPC case. In our case, yes.
Yes, it is part of affidavit.
Yes, my lord. This is part of the affidavit, my lord.
Yes.
Para 36, my lord, here we have clarified our stand, my lord. May I read, my lord? That the humble deponent denies each and every statement made in para 64 of the writ petition. Begs to state that the instant writ petition has not been filed bona fide, but to agitate the matter unnecessarily just to harass the state government on such false and frivolous grounds which are not substantiated, and to delay the acquisition process, to find itself a way to abdicate its responsibility to pay compensation for land acquisition. The humble deponent further begs to state that the petitioner is misconceived of facts and law, and immaterial pleading has been pleaded before this honorable court and has caused inordinate delay, while furthermore curtails the right of the landowners and was precious time of the honorable court. Therefore, this instant petition is liable to be dismissed for devoid of the merit, and the petitioners may be imposed 12% interest along with the draft award from the day of notification till the payment of the compensation to the land owners for securing interest adjustment. My lord, this is the affidavit, counter affidavit filed in the writ petition filed by the NSPC, my lord. That is 242, my lord. And another issue, my lord. In this case also we have filed our affidavit, my lord.
Page number
In writ petition 230, my lord, we have filed our counter affidavit, my lord. My lord, may kindly take up our counter affidavit, my lord.
dated.
My lord, our counter affidavit, my lord, there is. That, my lord, in my copy, my lord, it is not given, my lord. I'm sorry, my lord. Counter affidavit filed by respondent number 2, my lord.
Respondent number 2.
Yes, my lord.
Yes.
My lord, may I kindly take your lordship to page number 6, my lord, para 9, my lord.
Yes.
My lord, my senior colleagues has also referred the case of G2 Miri, my lord, which was filed by G2 Miri. That was numbered as writ petition number 402 of 221, my lord. 2021. My lord, may kindly let me read this relevant para, my lord. That as regard to the statement made in para 13 of writ petition, the humble deponent begs to state that the application number so and so, title G2 Miri and another parcel land acquisition collector and 5 others was withdrawn by the petitioners, as that the petitioners and the NSPC came down to a mutual settlement whereby the land owners settled at revised low rate of amounts received as compensation than what was actually awarded. The deponent also stated that compromise between the land owners and NSPC in the above mentioned case occurred because the landowners agreed to it. The deponent further states that the present petitioners are seeking relief of this disbursement of compensation amount as awarded by the Deputy Commissioner. The government at their behest cannot force or insist the landowners to come down for a mutual settlement compromise when the landowners does not agree or wish for the same. Exactly, my lord, as my senior colleague says, argued, my lord, advances argument, my lord. In G2 Miri's case, my lord, there was a settlement. In fact, the petitioner, they were ready for the outside court settlement, my lord. So therefore, they come down to the exact awarded, lower to the awarded amount, my lord. Here in this case, my lord, the petitioner, my lord, they are not ready for this outside court settlement, my lord. So we, as a government, cannot force anyone to come for this outside court settlement, my lord. So that is the issue, my lord. Therefore, this writ petition has been pending, my lord. They are trying to get the relief from this honorable court only. They are not ready for the outside court settlement, my lord. So this, my lord, this is our affidavit in this case, my lord. So since they are not ready, petitioner in this writ petition 230, my lord, they are not ready for this outside court settlement. So we cannot force them as done in the GP case, my lord. So that is my short submission. my lord.
Okay, okay. Argument concluded, order for judgment reserved. So, Mr. Tewari, can it be before Sunday, before Saturday?
My lord, I'll try.
Because I'll be available in the principal seat
Yes, my lord,
Monday
what I will
onward.
do is, my lord,
Then you can,
my lord, since my lord,
yes,
he will
yes.
be with the lordship, I will take his phone number and email ID. Mr.
Okay,
Saxena will take and we will pass it on to him. I will try to make it as soon as possible.
okay,
Because even if my lord goes out somewhere, since his number and email ID will be there, it will be
Okay.
sent to him directly.
okay, okay,
With the, since Mr. Das's number is with me, so I have no difficulty, I will give it to him.
okay,
And he has to give me his copy also.
okay,
So, yeah, I will give a reply to whatever submission he has made.
okay. So.
And some difficulty I would read the code order.
28.
My instruction is that my client is ready to forego 2 years replacement. That much only, that offer only is given.
Yes.
Otherwise, you know, the RFA, being a consent decree defined under section E of this law, and it is not maintainable under section 96, subsection 3, with other 41. So on merit, I am not going to learn, only that this particular aspect, only two years increase may be quite long.
Yes, what is your instruction?
Only my humble prayer will to 3. I am asking for 3 years, up to 3 years maybe exempted.
Yes.
Yes, up to 3 years only. It's been almost 8 years. So out of 8 years, only I'm seeking also 3 years exempted because delay has been made by them only, not for me. So on that consideration, I'll
Okay, 3 years then.
yes.
Well, my instruction is like 2 years.
Maybe, but it is on the part of the court that you come down another 1 year.
In that case, may I make a small request? One line. Although Mr. Sarah submitted his instruction for 2 years, however, this court deemed it appropriate to add 1 more year.
Okay, okay,
So
okay,
that you know, like, not unsafe.
okay, okay, okay,
Grateful.
okay.
Highly obliged.
We dispose of the petition then.
Okay.
Okay.
My lord, the authority there proposed to go for press tender.
Pardon?
Press tender. They're trying to propose for press tender, this matter. Since admittedly some of the officials' spouse was there. So now they are going for retender.
Retender.
Yes.
Pardon me?
If that is so, my lord, I have,
He can
with that
They
observation, my
can
lord,
participate.
the case can be closed, my lord. I don't want to also install the process, my lord. Only that should be in fair manner, my lord. I
Pardon?
think all process should be in fair manner, my lord. What happened in earlier tender, my lord, the spouse of chief engineer participated, my lord. I have objection to that, my lord. If they are going for retender, my lord, with that observation, this case can be closed, my lord.
Okay. Heard Mr. L. Parme, learned counsel for the petitioner, and also heard Mr. Z. Tare, learned standing counsel for the Rural Work Department for the respondent number 5. You put this paragraph number 2. Order dated 5/12/2024. Mr. G. Tarak, Learned Counsel, Standing Counsel for the respondent number 125 submits that the respondent authorities will go for retendering of the project as the wife of the chief engineer.
That is not necessary, my lord.
Not
My
necessary.
objection in this petition is that, my lord,
That
but
may be not
for
necessary.
disposal, my lord, that would be not necessary, my lord, the recording
Okay.
of that, my lord.
Okay.
Only observation, my lord, they will retender, my lord. If that is so, my lord, I humbly believe, my lord, I have a right to participate, my lord. So I have no objection, my lord.
And as such, this writ petition may be closed. Mr. Parmel, Learned Counsel for the petitioner, submits that if the respondent authorities will retender the project, then he has no objection and he will participate in the said process. In view of the submission of learned advocates of both the parties and as agreed upon, this writ petition stands closed. The authorities shall retender the proceed project. Time frame is not required.
Not because only, my lord, may aid, my lord, retender with due process of, or by following a due process of law, my lord. That may be, earlier
In accordance with law.
in accordance law.
Publish.
Highly obliged.
Mayor, your lordship. Your lordship, this is related to compensate appointment. The petitioner is the daughter of the deceased person. The deceased person was serving at Government Middle School, Native Air, Itanagar. Your Honor, she passed away during her service time. At last, she was assigned with the duty of APC preliminary examination. So at this stage, Your Honor, the notice may be issued to the other party.
Yes, who is for the respondent? Tagum. Heard, Mr. Your good name?
Tinima.
Learned Counsel for the petitioner. In this petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities. For her appointment in the post of primary teacher or any other post commensurate with her educational qualification in persons of die in harness scheme framed by the state of Arunachal Pradesh by number OM number 4 of 2001 dated 12/7/2001. The grievance of the petitioner is that her mother, who was working as in which school she was working?
Primary teacher, PRT.
Who was working as primary teacher in the Department of Education and serving at Government Middle School, Niti Bihar, Itanagar. Passed away on 27 November 2020 while she was attending duty during the COVID-19 pandemic. And she was the only earning member of the family. And thereafter, the petitioner has submitted an application to the respondent authorities on February 11 of 2021 seeking consideration for completion of appointment on any suitable post commensurate with her educational qualification. And the said application was duly forwarded by the Deputy Director of School Education, Government of Arunachal Pradesh. But the said representation failed to yield any result. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by Mr. Tagum, Current Standing Counsel. However, extra requisite copy of the petition will be furnished to him during the course of the day. List the matter after 4 weeks.
Deeply obliged.
No, Lordship. This is land compensation matter, Lordship.
Hmm?
Land compensation. First of all, I would like to this page number 47, Lordship. Annexure 1. This is the notification, Lordship.
Page number?
47, Annexure 1. 47. As per, yes, as per this 4747, Annexure 1, the government of Arunachal Pradesh was land was supposed to be acquired for moving to Yingkiong area for construction of highway. In this case, Lordship, this acquisition is under Zoom Lane, Section 10 of the Zoom Lane Regulation Act 1947, whereas lane is not under the Zoom Lane. It is a areable lane. It is a shuttle lane. It is within the town area. Even then, this objection was raised, even then the matter was settled. May it be Zoom Lane or may it be shuttle lane, land
Then the
compensation, fair land
compensation was,
compensation has to be given.
Compensation was assessed.
Yes, assessed.
Thereafter,
Accordingly, Lordship, kindly see page number 62. Page number 62, this is the type copy. This is the circular issued by the ADC for the Deputy Commissioner Yingkiong, in which kindly see circular number, just this is a very relevant phase, relevant paragraph. It is to inform all the stakeholders that the compensation assessment committee shall carry out the assessment of the land and properties from 0.00 kilometer in near Tri-Junction Road, powerhouse of Yingkiong to Moying. That is, Yingkiong is the district headquarters of Upper Siang district. BRO Road on 4/6/2022. Accordingly, this land compensation assessment committee proceeded the assessment. And then, Lordship, this committee has, Lordship, determined page number, relevant page is page number 69, Lordship. Annexure 11. In this, as per the relevant rules and guidelines of the land compensation, to assess the land compensation, this in the page number 70, paragraph number 3, it is the
page number?
Page number 70, paragraph down below, paragraph number 3. Now, therefore, this is a resolution cum settlement, in which now, therefore, language used by the committee is now, therefore, having consulted all stakeholders in the proceeding, the board has arrived at a conclusion that an amount of 20 crores 21 lakhs to 20,551 rupees is found to be a reasonable compensation in accordance with the office memorandum charges read with section 10 of the land Zoom Lane Regulation Act 1947. Estimate calculation sheet is enclosed with the proceeding. The award may be finalized in accordance with the above proceeding. Accordingly, kindly see, then
No, now you tell me on what basis they have reduced the compensation amount.
compensation is not released, but there was a dispute. That is why this petitioner is before this honorable court. Lordship, then award.
Dispute regarding what?
This is the settlement. Settled amount is in between the landowners and the government is 20 crore plus. It should be 20 crore plus. Then page number 72, annexure number 12. Kindly see. Down below again. Serial number 6. 6 sub clause D. Award was
That's all
passed.
right. Then how the amount is reduced to rupees 7 crore?
That is why award, this is the illegality, Lordship. That is why this petitioner is before this honorable court.
What is,
Award under.
what is that notification?
No, there is no such notification. Everything was arbitrary. It is illegal. Without the participation of the landowner, the property owner, this amount has been reduced. Without,
On what basis they have
there is no way.
subsequently calculated it as 7 crore,
That is
70 lakhs?
that is my case. Why this has been there? Why that is to be there? That is the case. As per the award has been passed on section 10 of Juvenile Regulation Act 1947. This is the this is kindly see 20 crore plus. Accordingly, Lordship, and then Lordship, as per the what was the objection, page number 75 of the WFE. Kindly see, this is the objection raised by the director. What is the objection? Objection is, kindly see, it last paragraph, second last paragraph. Sir, may I read the content language? Sir, with reference to your letter number Sergeant says that is 6/6/2023, and to say that the summary proceeding to determine the reasonable compensation as per OM notification dated 26/2021 is found not as per the prescribed format circulated by number Sergeant says. Also, as per the manual 2022 administrative charges for acquisition of the land for all kind of project except defense and highway project is 10%. Establishment charges is 7% and contingency charges is 3%. Whereas 3% charges, establishment charges 1% and contingency charges 2% has been worked out. It is therefore requested to revisit the summary proceeding and land acquisition estimate as per the prescribed format in terms of the manual 2022 for taking necessary action, please. Accordingly, this application was letter was written to the Deputy Commissioner Ying Kyung by the Director Land Management. So what has happened? The Deputy Commissioner Ying Kyung has, as per this in pursuance of this letter, press one phrase that the press estimate has been again forwarded to the director, in which page number 76 and annexure number 14. This is notice. Yes, 20 crores, not 20 crores. And then page number 78 annexure number 16, page number 78. This is Secretary Land Management. What he has done, he has constituted a committee to finalize what has been already settled by the Land Assessment Board. Yes, this one prevailing order has been, direction has been given, saying that to inquire upon the already assessed amount. Accordingly, 5-member committee was constituted, in which member was appointed. This in which page number 79, annexure number 17. This is including the same deputy commissioner who has assessed the assessment, land compensation assessment, SP concerned, PWD Ying Kyung, commander of DRTF and DLRSO Ying Kyung. Completely this committee has been changed. Previous committee has been dropped and except deputy commissioner. and except Deputy Commissioner and the Commander-in-Chief of the DRTF. So, as per their committee report, page number, this is type copy is 81, page number 81, annexure 18. Approval of land acquisition land acquisition estimate against the acquisition of land for construction of Yingkyong Mowing Road charges as. In this, as per the committee report, 7 crore 70 lakhs 69,271 has been approved by this land, this Secretary Land Management by discarding the previously negotiated amount without the participation of the landowners. That is without any justification. That is why there is a voluminous report which I could not be enclosed, but this already this some of the report says that as per the old bill and as per the new bill, it is at page number 82, annexure number 19. Some of this we have again even this talk to the Deputy Commissioner income, but he is not ready to furnish all those details. That is why we cannot that in this connection this record may also be called for, and at this stage a notice may be issued to the
Mr.
exactly
Kamlo?
what had happened.
Yes, madam.
But yes, at this stage notice may be issued, madam.
Heard Mr. T. Tapak, learned counsel for the petitioner, and Mr. Kanduk, learned standing counsel for the respondent number
2 entry, my lord.
2 and 3, and Madam
1, 4, and 5.
1, 4, and 5, and respondent number 6. In this petition under Article 226 of the Constitution of India, the petitioners have applied for issuing direction to the respondent authorities for awarding them compensation as per assessment made
9th of May 2023. 9th May. Page
On
number
9th of
annexure
May.
11.
while proceeding on number YKLM 71 stroke 2021 between bracket PT Roman 10 dated 9/5/2023, and also to cancel the assessment order dated what is the date? The assessment, second assessment.
Second assessment is there is not given, but approval order is there also. As per the approval order, it is shown on the record that it
And
is
the
on
approval
3rd
order-
July 2023.
That approval order in the month of February 2023. File number LMD -13011 within bracket 11 stroke 26 stroke 2022 stroke 2102 C stroke NO stroke 62375, page number 81. Sir Tapak, learned counsel for the petitioner, submits that the petitioners are project affected families. And their land was acquired by the respondent authorities for construction of road from Inkium to Moing, which indicate 0.00 km to 4.5 km. And the respondent authorities have assessed after negotiation with the petitioners, the compensation amount of rupees 20 crore 91 lakhs 20,551. But subsequently, the same has been reassessed on the basis of one letter dated 3rd of July 2023 issued by the director Director of Line Management. And thereafter a new committee was formed without discussing the same with the present petitioners, and thereafter the amount was assessed at rupees 7 crore 70 lakhs 69,271 rupees by letter dated nil February 2023. Mr. Tapak, learned counsel for the petitioner, submits that the aforesaid assessment was done behind the back of the petitioner, and as such the same is illegal and arbitrary, and therefore Mr. Tapak contended to say to the state. The submission of Mr. Tapak needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by all the respondents are
represented.
Since all the respondents are represented by their
can give
counsel,
extra
no
copy.
formal notice is required to be issued. However, it's the requisite copy of the petition be furnished to them during the course of the day. This is a matter after 4 weeks. In the meantime, Mr. Kamduk, learned standing counsel for the respondent number,
2 entry, my lord.
shall produce the file,
Produce the record, assessment record.
produce the assessment record before this court on next date.
Yeah. And in the,
List after 4 weeks.
on that day, they say, I have, there is a prayer for interim order. That may be on the next day, that may be.
The interim period of the petitioner will be considered on next date.
Lordship, extra copy by Bishop.
Yes.
Extra copy.
Number 29.
My lord, I have a small prayer before the upgraded items are taken up. Admission item number 7 to 10.
Yes.
Item number 7 to 10, my lord, in admission before the upgraded items are taken up. In this case, my lord, PWD, state PWD is one of the respondents. The council, my lord, he is absent today. I have just come to know.
My
actually.
lord, I have come from Guwahati, Alhamdulillah.
No, it's a different matter. It's a different matter. So anyways, this cannot take place today because the PWD council is not there. So it can be taken up next week, my lord, preferably on 19th, my lord. If it can be
19th.
fixed, my lord,
Okay.
my lord.
On the pair being made by Mr.
Pathak B. Pathak,
Learned counsel for the petitioner raises the matter on 19th.
19th of December. Deeply obliged, my lord. 7 to 10, my lord. Same orders.
Okay.
Okay.
Okay. Okay.
Number 29.
May I please, Your Lordship? Your Lordship, I was appointed, I was constable under ITBB, my Lordship. I was appointed in the year 2004. On 14/9/2016, I was absent from duty only for 3 hours. And due to that absence from duty for 3 hours, a proceeding was drawn, and ultimately that culminated into my termination by the impugn order dated 24/1/2017, my Lordship, which is at page 31. This is the impugn order.
Mr. Kato, you were for?
My lord, I am for all respondents, my lord.
All
ITBP. So, my lord, in this case also, my lord, if LCR is required, my lord.
LCR already on the last occasion, LCR has been, the court has called for the LCR.
Direction.
Yes, my lord.
Whether
LCR
it
has
is
come also.
produced?
It has come also, my lord. My lordship. Now, may I proceed, my lordship? Okay. On the last occasion, to occasion, LCR has been called for.
Pardon?
My lord, it was available on the last occasion.
When it was called for?
My lordship, kindly peruse the order, my lordship.
If directly it is transmitted to this honorable court, my lord, that I haven't any
My lord,
information,
it
my
was
lord, but
produced and a hearing was also taken, my lordship.
Pardon?
A hearing was also taken. With the LCR, my lordship. Anyway, my lordship, let me proceed with the case, my lordship. They have filed affidavit in opposition, my lordship.
If the record is required and if the record is not available before the court, how can?
It was available, my lordship. On the last occasion, it was available. I don't know why, because the court has called for producing the LCR, my lordship, and they produced the LCR.
So there is direction of this court on 19/6/2024 to produce the original record of the
Yeah.
disciplinary proceeding.
The produce.
Where is that record?
my lord, I haven't received it, my lord, so far.
You have not received it?
Yes, my lord. So, my lord, in that case, my lord, I may be allowed to again, my lord, remind the my lord, department to send the LCR, my lord. So that thing will be fixed, my lord, in the meantime.
My
I
lord,
will consider-
I may be hard because on the last occasion when LCR was there and the honorable.
No,
the
you
court
tell
had
me,
matter-
without the record, can we proceed with the
Well,
matter?
they have filed the affidavit in opposition, my lordship. Let me complete my part of the hearing, my lordship. On the next day, my lordship, even through video conference also, my lordship, I can attend, my lordship, because from Guwahati, my lordship, I'm attending everything every day, my lordship. But every day that case gets postponed or adjourned.
No, what to do? And unless the record is available before the court,
It was available on the last day, in the last 2 days also available. And the
My lord, this
honorable,
honorable court wanted to see the, my lord, the proceedings of the, my lord,
Yeah.
magistrate, my lord.
Yes.
My lord. That
so
was the
not
whole,
in
my
a
lord.
piecemeal manner. Let the record come.
Yes, my lord. Well, so that may be fixed. I'll come.
But then these judgments may be kept in the part of the record because I'm relying on some of the judgments, my lordship.
You file it at the time of hearing. Pardon, Mr.
SB Lashkar.
ML Laskar.
SB Lashkar. SB Lashkar. madam.
HB Laskar, Learned Counsel for the petition. And also heard Mr. M. Kato, Learned Counsel for the respondents. Mr. Kato submits that he has not received the record of the disciplinary proceeding initiated against the present petitioner. Though a direction was issued by order dated
16.
File order dated 19/6/2024. Accordingly, it is provided that Mr. Kato shall produce the record of the disciplinary proceeding of the petitioner before this court on fixed date. You suggested that.
My lord, if I suggest also next time, because several date, my lordship, some date records remain present in the court, some date doesn't present, my lordship. Any date, as you wish, my lord, as you wish.
When? January
Madam.
21st. Okay, in the event of failing to produce the record on that day, the court will proceed to hear and dispose
Madam.
of the matter on the basis of materials placed on record.
Deep level.
My lord, after the departure of Mr. Das, all of a sudden I recollected, I totally forgot to mention at least one point. I wish, of course, I will give a write-up to your lordship, so there is no difficulty. There I could recollect later on, London Advocate General had mentioned to the award, saying that in the board, NHPC was a member, representative of NHPC, that word was shown. And then the signatures were shown. I checked them, my lord. NHPC was not a party to the award. Representative of NHPC was mentioned as one of the member of the board. He never attended the meeting, and in the signatures, my lord will find his signature is not there. I will clarify in my write-up. So that point. Now, my lord, in this case, I'll just come to straight away, my lord, the relevant portion.
Yes.
My lord, the list of date I had earlier given to your lordship.
Yes.
From there, my lord, I will point out the relevant portions only. 14/7/23, my lord, is the date of suspension, the first date. 28/9/23 is the initiation of departmental inquiry for major penalty, because memorandum of charges were served on that date, 28/9/23. Followed by, my lord, 22/11/23, revocation of suspension. Revocation of suspension. 19/1/24 is the inquiry report. I will start with the inquiry report, the relevant portions. 29/40, the page number, it begins from page number 29 of the writ petition. The relevant portion may not start from page 31. Introduction part I will skip. Details of witnesses and other things given. Page 32, brief of charges framed against Inspector such and such and Sub-Inspector Sushant Gaurav Shah.
No, in the disciplinary proceeding, both were exonerated.
Both were exonerated. I'm coming to that. I'm showing only the relevant portions. My lord, it is the first.
No, Mr. Tiwari, instead of going through the departmental proceeding, this report, let us go to the order passed by the.
I'll come to the order, but something is connected with the order. I will just show, my lord, how the inquiry officer dealt with the whole thing. Only very, very small portion. Nothing big.
Page number?
Page number, my lord, it is, I'm holding the petition 197, WPC 197. I hope my lord is holding 197.
Yes.
Yes, that is the petition. Then page 32, column 4, there are 4 charges that were admitted, dropped or not proof. I will skip it. Details of witnesses. I will skip all this. Brief statements, documents produced, submission of charges. I'll skip everything. I'll just come to All the three charges, my lord, will find. I will show your lordship from assessment of evidence, page 38. Assessment of evidence, just to show how arbitrary DGP was. I am pointing this out. Page 38, assessment of evidence in respect to each point. Article of charge 1, para 1. The article 1 is, whereas on 11/7/23, Inspector Milli Gai and SI Sushant Saurabh Jha, such and such, PS along with the team of Delhi Police led by Inspector Girish Jain, conducted random vehicle checking at UPR Tri-Junction Point. During checking, they recovered 6 stolen vehicles. However, the recovery of stolen vehicles and apprehension of the individuals have not been made entry on GD book of Naharlagun PS by Inspector Milli Gai and SI Sushant Saurabh Jha. So the core is they did not make a GD entry. Now, my lord, how the evidence has been assessed, my lord will see. The evidence placed on record with the inquiry order, evidence produced by the charged officials and the defense witnesses, the statement of the independent witnesses established the following. 1. The checking team of Naharlagun police station was not led by the charged officials as alleged, but was led by then OC PS Naharlagun Shri Angat Mehta IPS and then SP Capital Shri Jimmy Chiram IPS. 2. On the 11/7/23, the GD charge of PS Itanagar was Mr. Angat Mehta IPS, who was himself on the spot during the course of checking, and the checking was being done by Delhi Police. Hence, the responsibility of making the GD entry as per the norm lies with either the OCPS Naharlagun or the Delhi Police team. 3. The recovery of the stolen vehicles and the examination of the owners of the cars has been mentioned in the Naharlagun Police Department ED by Delhi Police team, but due to late arrival at police station and then the time taken in writing statements of the owner, the said entry was made late and was made on 12/7/23 at 0047 hours. So GD entry was made, it was made late. As to charged officials were not responsible was established. Then the charge 2. Whereas on 11/7/23, Inspector Milli Gai and SI Sushant Saurabh Jha, in collaboration with the team of Delhi Police, called the individuals who had been caught with the stolen vehicles during vehicle checking at UPR Tri-Junction Point to Naharlagun Police Station and asked money to save them from legal action for involving in procuring a stolen vehicle. 3 individuals, namely Mr. Such and such, such and such, and such and such, have paid hefty money to Delhi Police through SI SS Jha. Now, the evidence placed on the record with the inquiry order, which includes but not limited to the CCTV footage of the PS, evidence produced by the charged officials and the defense witnesses, a statement of independent witnesses established the following. 1. The 3 individuals, namely such and such, such and such, such and such, have denied paying any money or for that matter being asked to pay money either to Delhi Police or to SISS. 2. Nowhere in the CCTV footage of PS Naharlagun on 11/7/23, SISS can be seen even interacting with any of the 3 individuals mentioned in the article of the charge or receiving anything from any. Then the 3rd charge. Whereas SI Sushant Saurabh Jha had deleted CCTV footages of the Sang Hotel, Naharlagun, dated 11/7/23, and thereby causing disappearance of electronic evidence related to illegal money dealing of SISS Jha and one Dolang John. The evidence placed on record with the inquiry order, evidence produced by the charged officials and the defense witnesses, a statement of independent witnesses established the following. 1. The independent witness, Sri Such and Such, who is the manager of the said hotel, had totally denied this charge, stating that the CCTV footage of his hotel was not deleted by anyone and that the said DVR might be faulty as there have been multiple instances of auto delete. 2. The said individual, Dolang John, denies giving any money to anyone. He even denies being asked for money by anyone. 3. The CCTV footage of such and such clearly establishes the fact that Sri Dolang John neither interacted with SISS Jha on the fateful day, nor SISS Jha left with him from police station. So, findings on each charge: charge 1 not proved, charge 2 not proved, charge 3 not proved. Observation about the conduct, such as said, everything is hunky-dory. So, this is not the inquiry report. Now, on this inquiry report, the order of the disciplinary authority. I will skip the first portion. He has quoted the charge verbatim. Then comes my lord, after the Article 3, I am reading. Page 41. Sri Nikom Riba, APPL, then DYSP crime, PHP Taragar, was appointed as an inquiry officer to conduct an inquiry into the charges leveled against Inspector Milli Gai and SI Sushant Saurabh Jha of SP Office Niljuli. Inspector Chumbi Karan, RISP Office Niljuli, was appointed as a presenting officer. The DE was conducted in respect of the charge leveled against Inspector Milli Gai and SI Sushant Saurabh Jha of the SP Office Niljuli, as mentioned above. The inquiry was conducted meticulously by following all the rules and guidelines by maintaining a separate daily order sheet. The delinquents were given enough chance to defend themselves by allowing them to engage defense witnesses and documents in their favor. During course of the preliminary hearing, the charged officials, Inspector such and such, and SI Sushant Saurabh Jha of SP Office Niljuli have not admitted the article of charges leveled against them. Hence, regular DE hearing was proceeded against the charged officials as per rule. After completing the DE hearing, the inquiry officer submitted his report to the undersigned with the findings that charges leveled against Inspector Milli Gai and SI SS Jha of SP Office Niljuli under Article 1, 2, and 3 of the memorandum are not true. I have carefully gone through the departmental inquiry report, other relevant reports, and representations of the charged officials. I do not find any reason to disagree with the findings of the inquiry officer. Hence, I do accept the DE report in which all the article of charge 1, 2, and 3 leveled against the charged officials, Inspector Milli Gai and Sushant Saurabh Jha of SP Office usually are not proved. Now, therefore, by virtue of powers conferred on me by Section 5 of Rule 13 of such and such, I do hereby discharge Inspector Milli Gai and SI Sushant Saurabh Jha from article of charges. Further, the period of suspension with effect from 14 July 23 to 22nd November 23 is treated as a spent on duty. Inspector Milli Gai and SI SS Jha may file his appeal such as that. Why should they file appeal? Because it was in their favor. So, my lord, they were exonerated of all charges. Now, my lord, in the meantime, thereafter, the promotion matter also sealed cover has to be opened. So, my lord, the file in connection with the promotion matter, the file goes to the DGP. DGP then suo moto opens up everything. As to what made DGP open up, what was his thought process, what made him pass the appeal order, that is reflected, my lord, in the office note. There is a detailed note, and that detailed note is a part of affidavit in opposition filed by the government. That I will show. That will reveal the picture. It is all handwritten, my lord, but it is typed out at page 61 of the affidavit in opposition filed by the state. 233 onwards. 233, 236, 237, from page 61 to 63, type copy at page 64. I will read from type copy. That gives us the reasoning, because order hardly contains much. And this reasoning, I would say, is perverse.
64 is the type copy.
Yes, madam. This I am reading.
Yes.
On perusal of the DPC recommendation, because DPC file had come to us. On perusal of the DPC recommendation for the promotion of SISS Jha from sub-inspector to inspector, it was found that the charges leveled in the departmental inquiry initiated against SISS Jha and Inspector Milli Gai has been exonerated by the disciplinary authority SP Nahar Lagoon, while order number such and such, on the basis of the findings of the departmental inquiry report submitted by the inquiry officer. The charges leveled against SISS Jha and Inspector Milli Gai were very serious in nature, as there was sufficient evidence, stood material on record, which clearly revealed in the preliminary inquiry. Now, my lord, his focus is the preliminary inquiry.
Preliminary inquiry, what is the purpose? Is there any material to draw by regular proceeding?
Fact finding. Now, my lord, all that was in the regular inquiry.
Yes.
So he says in the preliminary inquiry this was found. If that be the case, he is not saying that this evidence was not there or that evidence was not there. He is saying it is very serious in nature and the materials evidence on record which clearly revealed in the preliminary inquiry. Then he says, in the preliminary inquiry, conducted by Shri such and such, not making proper GD entries of the recovery of stolen vehicle apprehended on such and such at UCR tri-junction, malpractice, illegal money, dealing done. He is referring to all the charges. Such and such, in connivance with Delhi police officials and deleting of CCTV footage of Rasayan Hotel by such and such, which had record of money dealings. Based on the preliminary inquiry report, now from here comes the catch. Based on the preliminary inquiry report, both the delinquents are placed under suspension and departmental inquiry was initiated against them on gross misconduct, indiscipline, and dereliction of duty on their part of being members of disciplined police force. But in spite of the evidence, stroke material on record, the inquiry officer did not adduce the facts in proper perspective. Now, he is not saying that the evidence was not placed. He is saying evidence was not placed in proper perspective. Now, what is the proper perspective? What is the improper perspective? I can understand if the evidence was not placed in proper perspective and failed to assimilate the charges levied against the delinquents during the departmental inquiry. This is the material. Not considered, not placed in proper perspective and failed to assimilate the charge. This is vague. This is vague. It is not the case that the evidence was not there. Evidence is there. Disciplinary authority has come to the conclusion, no, it is not established. These are the facts. He said, no, it was not considered in proper perspective. This would not suffice. This is vague. My submission is this is absolutely vague and this is perverse. On this basis, DGP could not have exercised the power, which is per se extraordinary under Rule 31. That means, his entire thing is what was in the preliminary inquiry that has to be established. If what is in the preliminary inquiry has not been established in the regular inquiry, then no purpose is served. Again, you have to do. This is the. Therefore, by virtue of power conferred on me under Rule 31 of Arunachal Pradesh, such and such, I do hereby order that D initiated against SISS Jha and Inspector Nilli Gai be reconducted by an officer of the rank of SP to inquire all aspects in an objective, comprehensive, and wholesome manner. Moreover, explanation of the inquiry officer who conducted the inquiry be called for. No, now he is asking for show cause to the inquiry officer. Moreover, explanation of the inquiry officer who conducted the inquiry be called for conducting the departmental inquiry in a perfunctory and lackadaisical manner and not appreciating the evidence material available on record against SI Jha and Inspector Nilli Gai. Till the final decision is taken on the findings of the inquiry ordered by the undersigned against SISS Jha and Inspector Nilli Gai, the promotion case of SISS Jha from the rank of sub-inspector to inspector recommended by the DPCP capped in sealed cover. And thereafter, he also appoints the inquiry officer.
Where is that order?
That order, Annexure P6
Page number.
of 43, 44 of the writ petition. Just a minute. No, my lord, I'm sorry, it's not here. To Shri Shekhar Prabhu Desai. Yes. 2, page 45. Page 45. There are 2 below. De novo inquiry be conducted against Inspector Nilli Gai and SI Sushant Saurabh Jha by Shri Shekhar Prabhu Desai IPS, Superintendent of Police Crime, PH2, Itanagar from evidence stage. Practically, it's not de novo. Only thing is memorandum of charges there, evidence stage. That means fresh evidence will have to be taken all over again. This is what he has done. Now, I ask myself a simple question. If the inquiry officer there is a direction, inquiry officer show cause has to be issued. Explanation be called for. Inquiry officer is already appointed. I am already held. Who will dare to go against the DGP? Practically, my lord, he has made it very clear to the inquiry officer, which he himself has appointed, that this is what you have to do. It's a sham inquiry now. Whatever they will do is a sham inquiry. My whole submission is, my lord, this can't be the purport of Rule 31. The extraordinary power which he says is vested in him. He is a dictator practically. He can do whatever he feels like. Because nobody in the state of Arunachal Pradesh now will dare to consider the evidence impartially. They all know their fate. If poor inquiry officer is getting a show cause, having been called for an explanation as to why did he give this kind of a report, then there is a, then it is no longer a quasi-judicial inquiry. The whole idea is inquiry has to be impartial. Inquiry officer should not be under anybody's pressure. Disciplinary authority should not be under pressure. Here, inquiry officer will be under the pressure of DGP. He is the highest authority in the police. And the reasoning given is, number one, my lord, the findings in the preliminary inquiry. Number two, failure to assimilate the charge, failure to place it in proper perspective. He is not saying that evidence A, evidence B, evidence C, evidence D, this is the evidence. This evidence not looked into. This evidence did not consider. This evidence was not placed. He did not say that. He is not carving an exception. The principle of law is, if disciplinary authority does not agree with the report of the inquiry officer, disciplinary authority will have to carve out an area where he disagrees and then refers the matter.
Yes, there's that disagreement note has to
Yes,
be
yes,
served
because
upon the
this
delinquent
disagreement-
officers.
This disagreement note, period, I'm sorry to say, this is no note at all. This is no disagreement. Failure to assimilate the charge, not placing the evidence in proper perspective. He's not saying evidence was not placed, not in proper perspective. So his perspective may be different. He wants his perspective to be
Then
considered by
for
others.
that purpose of whether de novo inquiry can be ordered.
Cannot be ordered, will not, that is my humble submission. It is not de novo also. Will not, de novo, it's a sham of a de novo for the simple reason. Practically, it's a fresh inquiry on the memorandum of charges. There from evidence stage, he says, meaning thereby evidence has to be taken all over again. It's not de novo. My submission would be it's a fresh inquiry. Merely because memorandum of charge is already there, since you are recording evidence again afresh, it is as good as a fresh inquiry. Now, my lord, I come to straight away that principle laid down in the Supreme Court judgment. How to apply in this case? Oh, you don't mix up, please. Oh. Okay. ऐसा नहीं. My lord, Kanai Bera principle. I will straight away come to that. Lord, Kanai Bera, I had referred to on the earlier occasion. Kanai Bera, the relevant para is paragraph 6.
What is it?
The citation is 2007, 11 SEC, page 517. Lordship may take my copy. I have one extra
On the
copy.
other day, did you furnish it to me?
List of books I had given, my lord, but I have copy books.
Yes.
I start from para 6. The question as to whether a punishment of confinement to civil lines could have been directed or not should not detain us, as we agree with the contention raised by learned counsel for the appellant that the purported order dated 5/4/95 of the disciplinary authority was unsustainable in law. Rule 27 of the Central Reserve Police Force Rules 1955 inter alia lays down the procedure for conducting a departmental inquiry. Once a disciplinary proceeding has been initiated, the same must be brought to its logical end, meaning thereby a finding is required to be arrived at as to whether the delinquent officer is guilty of charges leveled against him or not. In a given situation, further evidence from here onwards it becomes important, my lord. In a given situation, further evidence may be directed to be adduced, but the same would not mean that despite holding a delinquent officer to be partially guilty of the charges leveled against him, another inquiry would be directed to be initiated on the self-same charges which could not be proved in the first inquiry. Now, my lord, here the court talks about the further inquiry. The further inquiry may not be all understand the meaning in the criminal jurisprudence also. Practically, here he says from the evidence stage again you start. Then KRT principle has been explained. This I read, my lord, para 7. In KRT versus CCE, this court, while considering the provisions contained in Rule 15(1) of the CCS Classification, Control and Appeal Rules 1957, held as under court. It seems to us that Rule 15 on the face of it really provides for one inquiry, but it may be possible if in a particular case there has been no proper inquiry because some serious defect, here are the principles, because some serious defect has crept into the inquiry or some important witnesses were not available at the time of the inquiry or were not examined for some other reason. The disciplinary authority may ask the inquiry officer to record further evidence, but there is no provision in Rule 15 for completely setting aside previous inquiries on the ground that the report of the inquiring officer or officers does not appeal to the disciplinary authority. The disciplinary authority has enough powers to reconsider the evidence itself and come to its conclusion under Rule 9. In our view, rules do not contemplate an action such as was taken by the collector on such and such. It seems to us that the collector, instead of taking responsibility himself, was determined to get some officer to report against the appellant. The procedure adopted was not only not warranted by the rules, but was harassing to the appellant. So, my lord, practically, if there is some serious defect which has crept into the inquiry, or some important witnesses were not available at the time of the inquiry, or were not examined, or for some other reason. The some other reason has to be, my lord, equally fundamental, equally vital, or similar to these reasons. Apparently, my lord, evidence was not placed in proper perspective, and failure to assimilate charge can't be that reason. He doesn't say that the witnesses were held up. He does not say that evidence was not there. Practically, we know the three reasonings we find. Number one, the preliminary inquiry. He says it was shown in the preliminary inquiry. Then he says charges not assimilated and evidence not placed in proper perspective. And then he takes recourse to this action. He also calls for the explanation of the inquiry officer. And then he appoints another inquiry officer. DGP does it all by himself under Rule 31. Now, my question is, I'm already prejudiced. I can't get any justice so far as Arunachal Pradesh police is concerned because the top man has gone against me. The only question I'm asking myself is whether such a power is vested in DGP under Rule 31. My submission is Rule 31 does not envisage such a power. The power cannot be unguided, uncanalized, and the discretion vested in the DGP to exercise such a power under Rule 31 is not an unfettered discretion. It is guided. It has to meet the tenet of Article 14 of the Constitution. It violates the basic canon of Article 14 of the Constitution. This is my submission. It is ex facie arbitrary, and the findings recorded therein are perverse. There's no finding. That is not my submission. My submission I have already made, not therein. And citations I had given to your lordship, and there, my lord, in my submission, I have given the citation. That is all, my lord, nothing else. Should I give the other two copies also? I have with me. I'll give.
Other?
There are other two judgments. I have referred to in my written submission.
On the same point.
On same point. The important judgment is KRD, which has already been quoted.
Okay. Okay.
So I'll just this is one. And then KD Pandey. That's all. Technically, KRD is the law on the subject. KRD in Tyagarajan also. Where is Tyagarajan? Here we know KRD. KRD has been referred to paragraph 8. Just one. Rajan may not care the principal has been written.
Heard Mr. P.K. Tiwari, learned senior counsel assisted by Mr. Saxena for the petitioner. Then Madam Pango for the respondent, release the matter on when?
Day after tomorrow, your lordship.
Day after tomorrow.
Yes, your lordship. The peace will present.
Right.
Organize, your lordship.
Lastly, only that part I've been worrying because it's totally skipped my notice. I will tell Mr. Das that NSPC did not sign the award and member was not present. So that is very important because because otherwise it would amount to waiver. I totally forgot. I'll mention it in my write-up. Oblige me not.
Your Honor, I'm appearing on behalf of Tabatagum, Standing Council for Health Department, Your Honor. This matter may be kindly adjourned for and fixed on Thursday, Your Honor.
Thursday.
Yes, Your Honor.
On the pair being made by Mr.
H. Thai.
S.
Thai. T.
Learned counsel appearing on behalf of Mr.
Tabatagum.
Learned counsel for the petitioner, SSL is the matter on Thursday.
Not, he's informing he's coming. But
Oh,
Mr. Tabu,
acha.
he's coming. But in this case, item number 12, and 13. But in this case, item number 361, 321 may be taken up. That is a main petition. But in this petition, only one point was to be clarified. That the submission of Mr. Tabu was that the cabinet had decided to restrict the post to 16. And therefore, your lordship had directed them to file an affidavit. They have filed an affidavit. In their affidavit, your lordship may kindly come to their additional affidavit of opposition. Only one point is to be clarified. Otherwise, my lord, the vacancy is repeated.
Page.
Additional affidavit. Page number 98, my lord. Page number 98, paragraph 3, before 3. Your lordship will see this B, GPMO dental 16. They have proposed the 16 post to the cabinet. Now, my lord, the proposal is at page 103, annexure 1. Annexure 1, 103, and you may kindly come to 104. This is the creation order of the 16 post. Which is 13 April 2016. The Governor of Madhya Pradesh is hereby pleased to accord sanction to the creation of the following temporary group ABCD non-plan for under Health and Family Welfare Department, Government of Madhya Pradesh.
At serial number?
Serial number, page 104, at serial number 21.
21.
Yes. This 16 post, GTMO, dental surgeon, 16 post. Now, they have created 16 posts and there was a vacancy because of the demise of Dr. S. Paul.
Now, there was total 70. But I have filed my, then Milord and Annexer 2 series, page 107. This is the cabinet note prepared by the department. Subject regularization of services of contractual general duty medical officers, allopathy, dental, and Ayush. Well, here at page 108 is the brief facts. There is an acute shortage of general duty medical officers and dental surgeons in the state. Recently, the following posts have been created by section number serial number 2. Number of posts created on 13/4/2016 16 is 16. It is indicated 16. Now, they have shown vacant post as 16. Now, my submission
You are referring to page number?
page number 108.
108.
The 107 is the first this thing.
Memorandum pro cabinet.
Yes, serial number 2, first page. Number here they have shown that was 16.
16.
Number I have filed my reply. And at page 112, page number 112, Annexer 2 series.
Yes.
May I read the final decision? This is 21 April 2017 cabinet decision. Issue of regularization of GDMO, etc. The cabinet decision of 4th January 2017 regularizing through APPSC has been declined by APPSC. The Honorable Minister held reported this to the cabinet. Therefore, after detailed deliberation, cabinet approved the regularization. Now, after that only the regulation order at page 113 to 150 were issued. This is what we have annexed in my read petition also. But I have filed my affidavit in reply, additional reply affidavit. But I have taken a categorical stand that may just read it out. However, the
Page number?
my reply affidavit, additional reply affidavit. I have taken a categorical statement
On dated?
I filed it on 6/12, 6 or 7. Additional reply affidavit.
Your Honor. Standing counsel, he's in court number 2, Your Honor. He's appearing in the matter, Your Honor. So kindly, this matter may be also listed on Thursday.
Not today.
Yes,
Let
sir.
him complete his part.
So I have taken a category statement that 16 posts were created and one
Paragraph number?
paragraph number 2 onwards.
Yes.
But, four lines. Because paragraph 1, 2, 3, and 4, they have given this this is based on reports. However, the petitioner begs to add that the Department of Health and Family Welfare had made a mistake in showing the total vacant posts of dental surgeons to the cabinet. The 16 posts were created on 13/4/2017, Annexer 1 to the additional affidavit, and there was already an existing vacant post. The total vacant post in the department has to be counted by adding these 16 created posts with any vacancy if it was available at the relevant point of the period. It is not disputed that late Chairman Paul has expired on 26/10/2015 and the post he had held had fallen vacant on 26/10/2015 onwards, and it was not filled by any means. Therefore, total vacant on 13/4/2017 when the 16 posts were created, and on 21/4/2017 when the cabinet took the decision to regularize the contractual service was 17 and not 16. It was due to the omission of the department that one post which was already existing prior to creation of 16 posts was not included. But that in paragraph 3, is that the cabinet had approved for regularization of the post indicated by the department. There is nothing to show that the department had indicated the vacancy as 17, but the cabinet had decided to approve regularization of only 16 posts. Perusal of the cabinet decision conveyed by the joint secretary at an exercise clearly reflects that the cabinet has taken the policy decision to regularize the contractual dental surgeon and approve regularization without indicating particular number of posts. Here I would like to reply to what Mr. Tagum has submitted, that the cabinet has decided only the 16, not other than that. My submission is, my lord, the vacancy has to be shown correctly. And the cabinet has decided, has taken a policy decision for regularization. They have not restricted the post to 16 or 17 or any other post. That in reference to paragraph 6 of the user text instead that authorities cannot make a distinction of the source of vacancy, like created post and post polling vacant due to death, superannuation. My sum and substance is that by omitting to add this one post has resulted in discrimination. I have been left out. Had they made this correct, indicated the correct vacant post of 17, the entire 17 would have been considered. So therefore, my lord, my submission is the decision to relax all these rules, the 16 or the 17, it should be considered as one of the recruitment process. They have taken a policy decision that should include all the vacant posts. And it should be deemed to include that one post also. Number, I would not say that this is totally an arbitrary way of omission. I submit that this is totally an omission by the department. So since this is a mistake, and since this is policy decision has been taken to regularize the contractual dental surgeon, so number does not make a difference. The vacancy matters. So since there is 17 vacant posts on the day when cabinet has taken the decision, so the regulation should be for the 17, and therefore, my lord, I, being a similarly situated person, where we have come from the same selection process, we have faced the interview together, our appointment we done together. We have been met as a contractual in the senior PVs also. My name appears as serial number 16, 17, and there were total 17 vacant posts. So, my lord, I should also be considered with retrospective benefit as was done. But in this case, in the earlier batch, prior to our batch, there also was regularization process. In the regularization process, some people, some doctors were regularized. And in that regulation also, one post was left out.
In the other petition.
I have indicated in this other petition, but before our case was considered, in earlier batch, our senior batch, that time also regularization process was taken up, and the same process. And there also one candidate was left out, one vacant was left out. He is Mr. Menbom Miji, and he had challenged his omission before your lordship. And this honorable court was pleased to direct for consideration. And accordingly, he has been considered. And in the item number 14, I have made that order also. But my lord, I have his appointment order, the type copy. Yes.
Well, in these petitions, I could not annex that order, but in the next writ petition, I have annexed the order. How he was given the benefit. He has been regularized with effect from the day when the others were regularized.
Okay, what about the other petition?
Other writ petitions, my lord,
391?
because we are in this 13 and 14, 14, and these cases were same. But the only difference is in this 13, 12 and 13, because of this vacancy position, it has a slight variation. And in this other writ petitions, my lord, you may kindly take up Article 14. This 12 and 13 are one and the same matter because 12 were filed later on. There is a state by honorable by your lordship, and one post has been kept vacant. Been directed not to fill that, so that post has been kept vacant also. So that was filed. That was ordered in resolution number 328. Item 2, 12 and 13 may be disposed of separately. Then in 14, we are also the same DDMOs. Our name comes from serial number 18 to 22, 18 to 23. So here, only the difference is there was some vacant post, but that was not filled up despite the cabinet decision. And your lordship may kindly come to page 46 of the petitions. 361.
How many writ petitions are there?
There are 3 petitions. 4 petitions, 12 and 13 is relates to Dr. Okan Thakur. 14 is
No, 14 is Tawayayu. That is we are the homeopathy doctors.
Oh,
15, 16.
15, 16. I'm sorry. Give me a hacha.
15. I remember 15.
15. Okay. Sorry, my lord.
Yes.
So these petitioners are 7 are also the same, but then only difference is that they would be coming within the journal considerations later, not directly to the serial number 17. My lord, here, my lord, first of all, now, my lord, here the cabinet has already taken decisions to regularize his contractual doctors. Your lordship may kindly come to page 46.
Yes.
Page 46 is an order on the basis of cabinet decisions. A committee was constituted to consider regularization of the staff of the health department. May I read, madam? This is the purpose of the cabinet decision that the 21/5/2021, the governor of Madhya Pradesh is pleased to constitute a committee with the following members to examine all cases relating to extortion, regularization of services as a one-time measures of those employees who are working on temporary contractual contingency basis in various government departments and other autonomous bodies, including municipal bodies, boards, corporations, etc. Serial number of edition. Now, madam, this committee has not yet been. Now, because of that, but in this, they have indicated the vacancy position also. Despite indicating the vacancy position, that nothing has been done, and therefore this has been the vacancy has been sent to the Public Service Commission for recruitment. There were 9, and one post, because of your lordship's intervention, one post was taken out of the recommendation, and 8 posts have been filled up.
So this is also regularization.
This is also regularization. All these cases are regularization. Number here in this case, and also the other one, we have already served 10 years. All has crossed more than 40 years. Now as per the RR, it is 31 years and relaxable for APSC because of this other ground, it is up to 35. Now, in any case, we are no more eligible for preparing the fresh recruitment process by the Public Service Commission. And
So how many petitioners are here?
here 7.
7. And 7 vacancies are there.
There were 7 vacancies when these decisions were taken. But, I had seen this morning. But I'll come back to them. I have seen this morning also. In their affidavit, they have also annexed the vacancy position. But I have also annexed in my writ petition, page 49. Madam. Page 59. Madam. The total is 9, and this the officer has deputy director has signed it on 13/2/2024. On 13/2/2024, there were 9 vacancies, and had these 9 vacancies been filled up as per the cabinet decision, because cabinet has already relaxed the rules, they have already decided that it should be regularized. Had they been done, then the petitioner in item number 12 and 13 and petitioners in item number 15 would have been considered. In any case, mother, since this 8 posts has already been filled up, there is nothing which can prevent this honorable court to direct for creation of posts, because there are ample possibility. And my lord, in any case, my lord, this Honorable Supreme Court also has, in Uma Devi case, has held that those persons who has been appointed through some semblance of human process and who has completed 10 years of service, they should be regularized. So that is, in this case, because we came bit late, at that time already was forwarded to the Office of Commission, they already issued the petition. Therefore, we do not obtain the interim order. Nevertheless, my lord,
No, if there is no vacancy, then from where they, in which post they will be absorbed, regularized?
vacancy, my lord. No, vacancy, my lord, in page 49, they have shown how this vacancy has.
No, these vacancies are already filled up.
No, as of today, yes. As of today, 8 out of 9, 8 has been filled up.
Only one is not filled up.
One is not filled up. and
But
that is-
how many petitioners are here?
Here, 7.
Then,
No, my resolution submission is, it may not be directed to be regularized against this vacancy because it already stands vacant.
then what
But
kind of order is
basis of-
required?
On the basis of their committees, at page 46,
Hmm.
let them take a decision within a time frame.
What decision?
This, page 46, this, may I again come back to page 46.
Hmm. No, if the posts are not there, then this is regarding regularization or absorption of service. But provided there is post, but if no post is there, then what to do?
Your lordship, under 226, direct the respondent authorities for creation of for post.
Mr. Tagore,
My lord.
get the post then.
My lord. My lord. My lord, first of all, my lord, their case, my lord, they are under NHM, my lord, National Health Mission, my lord. This National Health Mission is a program sponsored by the government of India, central government, my lord. Therefore, their appointment is contractual, my lord. And so for contractual, my lord, in other case, my lord, we have filed in affidavit clarifying, my lord, with regard to the regularization of 16 dental surgeon, my lord. For that, on administrative actions, a specific cabinet decision was taken only to extent of 16%, but the rest, my lord, no cabinet decision taken place, my lord. And for absorption, whatever it may be, my lord, this is the case of even regularization is a different thing, my lord. This is from NHM, my lord, not from the even full-fledged state-funded program, my lord. Whatever the salary they're getting, they are from the central government, my lord. And unless, my lord, there's a post, my lord, and even for, my lord, assuming, my lord, there's a, suppose, my lord, they are annexed the one cabinet, one decision, my lord, in at number 15, my lord, page 46, my lord, wherein even for regularization, my lord, there's a screening committee, my lord, headed by Chief Secretary. And we are not even member to that committee, my lord. Even if, my lord, if issue a direction to consider in a line of page 46 of, my lord, the order, my lord, the order has to be implemented by those screening committee headed by Chief Secretary, which is not before this honorable court, because we are not even party, my lord. So that's why, my lord, for safer side, my lord, it would be appropriate if the Chief Secretary, being the chairman, my lord, of the committee, if he's at least implemented, my lord. Because if order is passed, man, who will implement? Ultimately, the screening committee headed by Chief Secretary. We are not, the health department is not a member to this committee, my lord. They are the one to look after, my lord. Look whether these people, they can be regularized or can be absorbed, my lord. Taking into the financial position of the
Is
state,
it a permanent committee?
my lord.
Is it permanent committee? This committee constituted by the order dated 1st of January 2021.
It's not a permanent committee. This has been only assigned to look into this aspect only.
No, that is
Then-
why, my lord, even to look into this aspect, my lord.
No, whether this committee as on today exists or not.
My lord, that is why only they can tell, my lord. Because we are not a member, my lord. That's why, my
Unless,
lord.
unless we know about their existence, how can we make
That-
them a party in this petition?
My lord, that is why, my lord. So far, regularization part, my lord, my respectful submission, even on regulation, so far the contract employees on particular project scheme is concerned. My lord, regularization cannot be done, my lord. There's a settled principle. One thing, my lord, the appointment contract basis in the state full-fledged funded, my lord, within own state creation, my lord. That is another thing that understood, my lord. But so far, the contract appointment against the particular project scheme, the regulation is not possible, my lord. It becomes settled principle. Now, there's a distinction, my lord. So for Uma Devi's case concerned, my lord, that's with regard to the then is the regular continuously going on. My lord, here their appointment is under the NHA, my lord, on contract basis. And whether they're required to be regularized or not, now since
No, you are representing the health department.
but I'm only representing health department.
Respondent number 2.
My lord,
You obtain necessary instruction on whether this committee as on today exists or not.
my lord.
Why you are suggesting if the committee is not there, why should we include the committee?
My lord, my lord.
Hmm?
My lord.
Then in respect of other two petitions?
No, other my lord, other also my lord. We have filed, my lord. This regulation part, my lord, regulation,
One post is kept vacant
my lord.
as
That
per order of this court.
my lord.
Then in the other petition also posts are there.
Other, there's my lord, the recruitment has been done, my lord. In one post vacant, my lord, that we have said that, my lord, since that is they are claiming for regularization, my lord.
In one.
321 and 328.
Now, there, my lord, the one post is vacant, my lord. It's not to be filled up without leave of this honorable court, my lord.
Hmm.
Now, in that aspect also, my lord, they are seeking of regulation who are presently serving as a contractual under NHA, my lord.
Hmm.
And for regular appointment under the state, my lord. Because under the state, my lord, there's a recruitment rule, my lord. Recruitment rules is specified how that can be recruited, my lord. Only exceptional if there's a policy decision relaxing the rule, invoking Rule 16, then only. Otherwise, my lord, this cannot be done, my lord. We have taken our stand on that aspect, my lord. So for this regulation, present part is concerned, that could not be materialized, my lord. Although we have put up for appropriate decision of the authority, but administrative reform and the public service committee have turned down, saying that that is not acceptable.
Hmm.
So in that view of the matter, my lord, if this committee that which the annexed July 2021, my lord, if it is exists, my lord, then they are the appropriate authority, my lord, to examine whether they can be regularized.
Okay, then you obtain instruction, we'll keep it as parted. By tomorrow you obtain instruction.
My lord, tomorrow, my lord, it's not possible, my lord.
Why?
My lord,
Over phone you can obtain the instruction, even today also.
my lord, let it be a day after tomorrow, my lord. Problem is, my lord, in the telephonic, even I make telephonic call, my lord. Instantly, they would not be in position to give appropriate reply, my lord. So that's why even to take decision, whatever the reply.
Let your secretary remain present in the court.
As far as
Let him explain.
My lord, let it be on Thursday, my lord. Day after tomorrow, my lord.
Okay. Heard Mr. T. Patil, Learned Counsel for the petitioner. And Mr. Tagum, Learned Standing Counsel for the respondent authorities. Heard in part, list the matter on Thursday.
My
So
lord.
as to enable Mr. Tagum to obtain necessary instruction as to the existence of, as to the present status of the committee constituted by order dated uh, 1st of July 2021.
My lord, apart from the information, my lord, I'll submit my part, my lord, regarding there's a distinction, my lord.
Okay, on that day you can submit.
My lord.
Covert case, madam.
Covered case?
Yes, on payment of the land compensation. Madam, as per the decision of this honorable court, madam, in page number 54 to 57, madam, this covers entire things, madam. I may submit this, madam, decision of this, decision of your lordship, madam. And which was also upheld by the honorable division bench of this honorable court, madam. The matter of the fact is, madam, the land notification was issued in the year 2009, madam. And bill were assessment were done in 2016, not properly, just haphazard way, madam. And thereafter, madam,
No, Mr. Son,
Madam.
this appeal is pending before the Supreme Court, no?
madam, there is no any such matter, the stay order, madam.
Stay order is not there.
Madam, I am submitting this, madam. First, condemnation of delay was condemned by the honorable apex court, madam. And thereafter, this order was, interim order was modified. Issue of that matter, I think, madam, making payment of the bill, then compensation. I think, madam, I think not, and very interesting, my lord. Even after the judgment of the honorable court as well as division bench, my lord, the respondent number 4 and 5, they are not complying the order, that is solicitude, my lord, as provided under 30 of the Lara Act, my lord. And there also, my lord, on earlier occasion, this honorable court was also passed an order by Justice N. Tagia, my lord. My lord, I have already submitted the judgment copy. There also it was clearly stipulated that the area of the land shall be verified whether there is any land or not. There was a
So you have received some amount of compensation.
not
As
at
per
all, my
some
lord.
regulation.
Not at all, my lord. Not a single, my lord. Their contention is that the Lara Act came into force in Arunachal Pradesh in 2014, but they are not implementing. So, my lord, my humble prayer before you, my lord, let the respondent authority.
No, Mr. Son, you see, we may pass the order, but they may not implement it on the ground that the appeal is pending before the Supreme Court.
Well, that's for the order modified, man. Order was already modified, man.
That was modified.
Yeah.
Okay.
And I think, madam, there won't be any impediment in passing the, madam, necessary order, madam. And I have also submitted my affidavit in reply, madam, all the documentary evidence also, madam. So, madam, the petitioner are entitled to get the whole total compensation along with the madam, solitum plus 12% interest, madam, as per the Lara Act, madam.
Yes, what is your stand?
Let's see. I'll take it in this thing.
Pardon?
Para 11, Mr. Para 11.
Of your affidavit?
Yes, Mr. Page 23.
Your correspondent number?
4, 5, 9, and 10.
Affidavit dated 16 September.
Yes,
Paragraph number?
11.
11, page 23.
They are denying, my lord. The order passed by this honorable, my lord. Regulation 1947. They are strict to that only. In spite of, my lord,
Paragraph number?
11.
11, Mr.
No, in this affidavit in opposition of respondent number 5 and 9.
I
It is
mean, they'll
not
go
there.
by 4, 5, same, Mr. 4, 5, 9, and 10.
But here paragraph, no 11 numbers of paragraphs are here.
Those things doesn't.
I don't know who is
No included.
affidavit you are referring to.
Enclosure includes. Okay.
So, Sona, wait for some time. Where he had done? Can you check the status? This the Supreme Court website. You go to Supreme Court website. Thereafter, you try to find out this case status. But that is appeal, regular first appeal. Record video, this one. Pending. Next step. Next step. 15-1. Wait for some days. Next date fixed before the Supreme Court is 15-1. January. You take a printout of that order, last order. Because if their stand is also same here, that the appeal is pending. So even if we pass the order, they will not implement it.
But I want to just appraise your modified order of the Supreme
So
Court.
that's all right. That is there.
So there is no any
Stay. Now stay is not there.
Yes. So state hospital can do it,
But they will not do it on that pretext.
and they clearly laid down that order of the Honorable Apex Court that you have to deposit the amount. So they are not preparing even the bill also, my lord. Not preparing the bill also, compensation amount. Apart from the leave it, apart from this, my lord, the solicitor and the 12% interest.
Where is that award?
Award, my lord, as per the, my lord,
Page number?
affidavit in reply, page 4, my lord, as per the communication given to the learned government advocate to Miss T. Wangmo, government advocate, Guwahati High Court, Itanagar Permanent Bench, subject forwarding of detail of total amount of compensation and petitioner in connection to WPC number 439 AP 2023.
No, that award is where, at which page number?
Page number 5, my lord.
Page number?
5.
5.
Yeah.
Of your rate petition?
No, in their reply, my lord.
No, in your rate petition, where is the award?
No award is there. No mention of award. Oh. Oh, yeah. Yes. We have received and received. Let's share 5.
My lord, at that point of time, my lord, total award was not given because there are some dispute regarding the land, my lord. So after the order of this honorable court, my lord, in my affidavit in reply, my lord, page 45, annex of D, my lord.
Page 40?
45 2, my lord. Operative portion is, my lord, Operative portion is 76 to 78, my lord. So after this the order passed by this court, my lord, then my lord, the respondent authorities, they started to taking the measurement of the land. So as per this report, this is the award who has to be given the payment without making any solemn and 12% interest.
Where is that order?
As per this, my lord, page 4, my lord, communication given to the learned advocate, government advocate.
Is 4 of the writ petition.
No, my lord, affidavit. Four, 5, 6, up to 11, my lord. Here only petitioners altogether 17, my lord. They have given a detailed horticulture land areas, then forest area asset, then micro irrigation channel.
So this annexer 5 is the amount of compensation.
Yes, ma'am.
Then where is the calculation sheet?
Yes, sir, ma'am, they have not shown the calculation, my lord.
So then how can we know that the Solasium is not incorporated in the calculation sheet?
They have not given the, my lord, the calculation sheet. That is, even we have applied for the RTI also, that was not given, ma'am.
They have not given.
Not given.
You produce the record before this court.
Record of this detail of total amount of compensation.
No. From going by this annexer B or A, Mr.
Is that from B?
B.
Yes.
Can it be said that the Solasium is incorporated here?
It is not.
Then your affidavit is also incomplete.
Incomplete,
Produce the
yeah,
record
this is
before this
also
court.
dispute is there.
Pardon?
Even compensation, I mean like as per, I mean like all egg or whether new egg that has to be, I mean, compensated. It is still in dispute.
You show the record first.
Record means
Heard Mr. Tison, learned counsel for the petitioner, and Mr. So-and-so, learned senior government advocate for the state respondent. During the course of hearing, Mr. Son, learned counsel for the petitioner, submits that though one RTA application was filed by the petitioners for furnishing the calculation sheet of the compensation, yet the same was not furnished to him. It appears that the said calculation sheet is very much necessary to dispose of the present writ petition. And accordingly, it is provided that the learned government advocate shall produce the entire file relating to assessment of the compensation before this court On when?
Lordship, a record from which department? Actually, this is related to land revenue. DC.
DC of which?
Siang district.
Siang.
Now Siang, my lord, earlier it was East Siang,
Pasigat.
Pasigat.
You produce the record after 1 week?
It has been bifurcated from East Siang to Siang district.
Yes. Next, suggestion that today is
It means second week of next
before vacation.
before vacation, yes.
Hmm.
Anything.
All right, man.
Mr. Son, you can take these judgments with you. Victoria, where is the copy?
Before
Okay.
vacation, any day fix.
Printer is not here. Not working. Any other matter?
Number 25.
May I please, Your Lordship?
Yes.
Lordship, today the matter was fixed for implement of the necessary party.
Pardon?
However, Lordship, we could not ascertain the candidate who have been awarded the RO dealership. So we need further some more time to ascertain that one awarded candidate.
Okay. Heard, Mr.
Tiga.
Learned counsel for the petitioner. The learned counsel for the petitioner pays for granting him some more time. For filing an application for employment, here is allowed, list the matter after.
Lordship, any fix that? Any fix that?
When?
January 19.
January 19.
Yeah, December. Yes.
19 December or January?
December, Lordship.
December, okay.
Obliged.